can see the heading.
Is it already in the...
It's already loaded.
So, good afternoon and welcome back to the proceedings of our European Colloquium. This afternoon we are going to have 3 presentations, and the discussion will follow a short coffee break after the 3rd presentation. Now, I did ask Professor Leland to have some extra minutes in order to present some of the aspects of the process of Brexit, which he considers particularly important and crucial for us to know. And certainly he has the authority necessary to give us a full picture, which of course will be constitutional, will be legal, but perhaps also a little emotional, may I say so?
Yes.
All right. And which, of course, means that we really have a full picture about it. All right. Now, without further ado, I would like to give the floor to Professor Anna Gamper from the Institut für Öffentliches Recht at the University of Innsbruck. She will have to leave a little bit earlier, so let me thank you just since now for your presentation and for coming to Trento, although of course in your case the distance is not so long as to make your trip epical. But you are of course most welcome. Please, Anna.
Thank you very much. In fact, I'm going to stay until 5:20 or so.
Oh,
so
change
that's
your train.
possible,
Oh, that's
but not
fine.
until the end of the program. So,
Okay.
but there should be plenty of time for discussion afterwards. Well, thank you. I'm more than grateful for being invited here and for not having to speak about litigation within the federal government during our recent crisis, which is really terribly worrying, I think, but about litigation and the management out of court in the Austrian federal system. And I think the picture here is much more beautiful than the one that we are experiencing now within the federal government. I was wondering, when I prepared for this lecture, what, on the one hand, litigation meant. Does this mean management out of court when a dispute has already arisen? Does it mean also to avoid, to prevent disputes? And what are the respective instruments one can use for that? And also, what does the management out of court mean? I think, and I would like to explain this in the Austrian context later, and this sounds, I know, quite paradoxical, that there may be even a role to play for courts within the out-of-court management of litigation, namely not the classical role of a court, judges that finally authoritatively decide on an issue, but another role, for example, to give just an expert statement, for example, on a question referring to the allocation of powers before a law is made, and so on. I will explain this a little later with regard to Austria. Now, Austria is rather well known of its weak form federalism, so to say, because the allocation of powers is rather centralistic. The federal second chamber, called the Federal Council or Bundesrat, is both legally and politically a very weak chamber. The financial equalization is rather centralistic, and so on. But quite on the contrary, Austria is also quite famous of its highly cooperative nature, both formally and informally. And this high degree of cooperative federalism is quite useful when it comes to the out-of-court management of constitutional litigation. Even though the Austrian federal constitution does not contain an explicit provision on a general principle of, let's say, federal loyalty, solidarity, cooperation in general. And we have now heard some experiences before, like in the Swiss constitution, even though it was just written down what had been usual before. But also in the constitution of South Africa or Nepal, which is a very recent constitution dating back to 2015. So such a general principle provision is lacking in the Austrian constitution, but nevertheless, there are some provisions that, taken together, I think indicate such a principle. And I would perhaps first of all like to mention Article 22 of the Federal Constitutional Act here. I have to add that the Austrian Federal Constitution does not consist of just one document, but it is highly fragmented. In fact, it's a shock, I know, it consists of 500 different types of constitutional sources. It's crazy, really. But we tried to cope with this as scholars of constitutional law. And the main constitutional document is called the Federal Constitutional Act. It dates back to 1920. And even this act alone has been amended 125 times so far. So an extremely fragmented and also very flexible, over-flexible constitution even. Now, in this main constitutional act, in Article 22, there's a provision that says that both administrative authorities and courts have to assist each other. And this could be read as a sort of solidarity principle. However, it does not mention parliaments. They are excluded from that provision. And it doesn't have a particularly federalistic nature because it obliges all kinds of administrative authorities and courts, both at federal, land, and municipal level. And normally the provision is meant to imply the support with technical equipment, buildings, for example, to submit evidence from one authority to the other. But it is an indicator, not more than that, perhaps, for a more general principle of cooperation within the federal system. A much more important provision, perhaps, is Article 15a, which says that the 9 Länder among each other, but also the Federation and the Länder, may conclude formal treaties, like state treaties, but of course internally within Austria. And these agreements or treaties are formal, they are binding, and they may even concern legislative matters. This has become a very important practical instrument which is used very often, especially for so-called complex issues. Complex issues are issues for which not only one level, let's say the Federation or the Länder, are responsible, but it is one subject matter on which several competences apply under various aspects. So it's not a concurrent competence on the matter, but these competences mean responsibilities for different aspects of the same matter. These are complex issues such as spatial planning, for example, environmental protection, you mentioned it earlier in the Italian context, hospitals, schools, also asylum and refugee questions. So there are lots of these agreements on such complex issues. And the interesting thing is that when they concern legislation, the parliament of each level has to approve before the agreement is signed by the respective governments. Because, of course, when it concerns legislation, this cannot be done without approval of the concerned parliaments. However, the agreement must not amend the allocation of powers. The allocation of powers remains as it is. The agreement just says we agree on the common objectives, the common programmatic provisions, the common goals of this complex issue, and every level that has to adopt its own legislation under its own competence regarding a certain aspect of this very issue has to bear in mind that we agreed harmoniously on implementing these goals into one's own legislation. So this is really useful in Austria. And normally, the signature under these agreements is voluntary. So normally, neither the federation nor the lender can be forced into signing the agreement. But from time to time, a case has happened, namely that the federal lawmaker included a provision in a federal law that said when the lender don't sign the agreement, they may do so, but when they don't, they will lose financial resources which they would otherwise get under the Financial Equalization Act. I'm not quite sure whether these provisions were not unconstitutional, because indirectly they meant a binding force on the lender to sign these agreements. Normally, however, this is not the case, and there are even cases where the lender benefits financially from signing these agreements. For example, in the last autumn, the federal government at that time wanted the lender to implement legislation in their elementary school laws with a ban to wear headscarves. Children should not wear headscarves when they are attending elementary schools. That was the plan envisaged by the federal government, and the lender agreed. They got additional financial revenues, and finally they signed the agreement and now have to implement this headwear ban into their elementary school legislation. Perhaps another more general or preventive principle that could be mentioned here is the so-called principle or duty of mutual consideration. This is a principle that was just developed by the Constitutional Court. There is no positive provision in the constitutional text regarding this principle. It is judge-made law, so to say. And this principle means, according to the Constitutional Court, that neither the federation nor the lender may excessively undermine the other's legislation. The court literally said one level's legislation must not work as a torpedo on the legislation of the other level. However, it does not mean that one level would be allowed to absolutely usurp the other's matter, saying, well, I have to consider it, now regulate it. That's of course not possible. And it does not mean that one level has to pay absolute deference to the other level. It's just, a ban for, or banning excessive misuse or abuse of one's own power. And it is indeed a mutual principle. The court applied it both in favor of the lender and in favor of the federal government. It was interesting to see how the court derived this principle from the Constitution. This was a rather, I should say, diffuse reasoning, because the court alluded to the aforementioned Article 15a, state treaties possible for the federation, the lender, the equality principle, which with its inherent rationality requirement, and this is less positivistic and more nature law oriented, that it is inherent in any allocation of powers and any kind of federalism to have a harmonious legislation that doesn't conflict with each other. So several scholars were quite critical of this reasoning, but I think at least the result is convincing, even though perhaps the court could have used better arguments. And I mention it here as an example of an out-of-court management principle, because the court developed it in a classical judicial context, when, as a classical umpire, the court had to decide on a conflict between the federation and the lender because one law had been appealed to, challenged before the Constitutional Court and so on, all the classical powers that the Constitutional Court has. But it developed this principle from case to case, and it is now more than that. It's not just a resolution, the judicial resolution to one concrete conflict, but it is a preventive guideline. It is a yardstick that both the federation and the Länder know of. They use it when they make their own laws. They know and anticipate it. We find very often, both in the federal and the land legislation, that they considered it, because we find express provisions that say this act does not at all try to affect this or that matter. On the contrary, this law and also those that have to apply this law must consider this and that law of the other level. So that's the immediate impact of that principle as developed by the Constitutional Court. However, when a conflict has already started, a political conflict, what can we do in this case in Austria? And it came to my mind that in some federal countries, the federal second chamber would be a possible mediator, but not so in Austria, unfortunately. The Federal Council has some veto powers, mostly suspensive veto powers, and in a few cases also an absolute veto power. Of which it hardly ever makes use. But the Federal Council has no right to amend bills passed by the First Chamber. It has no power to suggest a compromise. There is no mediation committee between both chambers that could work out a possible solution. So the Federal Council is not very useful here as a possible body that could be interesting in this context. However, I would once again like to mention the Constitutional Court, but not again in this classical role as a final decider on disputes, but at a very early preventive stage, because one article in the Federal Constitutional Act, namely Article 138, provides that it is possible for both the federal government and the Länder governments to ask the Constitutional Court for pre-legislative scrutiny of a bill that has not already been resolved on in Parliament. And in this case, the Constitutional Court gives, so to say, an expert statement. It is not a power to state whether the bill is totally in line with the federal constitution, but only with regard to the question whether it is in line with the allocation of powers. That's the only question that the court may be asked when it comes to pre-legislative scrutiny of bills. And this power has been used quite often in the past. Now, not so very often, and I mentioned this before in the discussion, because now more or less both levels know how subject matters are handled and how powers have to be understood. But it is nevertheless a very useful competence. One level may ask the court preventively about its own intended law, but also with regard to the others. So there may be a possible conflict behind it, but the law has not been passed already. And the interesting thing here is that even if the Constitutional Court states, well, this bill would violate the allocation of powers if it were enacted as a real law, even in this case, the respective lawmaker could continue the legislative process. It does not really stop the legislative process. It's just like an expert statement. However, if the law is nevertheless enacted, becomes a valid law, it may be challenged before the Constitutional Court, but this time it is serious. And then, in such cases, the Constitutional Court will always say, I feel myself bound to what I former said. It was a mere expert opinion, but I find this binding on my real decision, so to say. And of course, this again is a preventive yardstick that may be useful, because the court threatens, at least at the very end of the whole affair. Now, I would like to mention a very special arena where a particularly high number of instruments pertaining to the out-of-court management of litigation has been developed. And this is the arena of fiscal federalism. First of all, let me mention the Financial Equalization Act. This is a very important act under which financial revenues are distributed between all three levels, the federation, the lender, and the municipalities that also come into play here. And it is an ordinary federal law. Formally, it would be possible for the federal lawmaker just to enact this Financial Equalization Act. But there has been a long and well-established tradition in Austria to negotiate this Financial Equalization Act before by the federal government with the lender and with the municipalities. And this is usually done every 4 years, because every 4 years a new Financial Equalization Act is enacted. And negotiations often take 1 year or so. They are full of disputes, and the media, of course, inform us about the stages of this negotiation process. But normally, the negotiations lead to a positive result. Normally, they finally undersign, all parties, all three levels, sign a political agreement. It is a merely political agreement, a gentleman's agreement. It is not a state treaty under Article 15a. A political agreement that they approve of these results of the negotiations, and they should become the main content of the Financial Equalization Act. And this act is enacted afterwards. Now, the fascinating thing is, and there have been such cases, that sometimes one single land or one tiny little municipality complains of the Financial Equalization Act afterwards, after it was enacted. And they say, well, now I disagree with the Financial Equalization Act, and I don't think it's constitutional because the federal constitution contains a principle that financial equalization needs to consider the capacity of every tier and every unit of this tier, and has to consider the administrative burdens on all of these tiers and so on. And sometimes one municipality, for example, goes to the Constitutional Court and says, well, I find the recent act violates this constitutional principle. And then the Constitutional Court will answer, you have reached a political agreement, and also the municipalities were represented by 2 associations of municipalities in Austria that represent their interests, and you gave your signature to that political agreement. And the court will presume, it is a legal presumption, that because they signed, the ensuing Financial Equalization Act will be constitutional. And only in excessive cases the court may consider to examine the Financial Equalization Act, but normally it will say, I will not examine it. I presume it is constitutional because you signed it politically only, but it will in this way get a legal nature almost. Another example pertaining to fiscal federalism is the so-called agreement on a consultation mechanism, which was concluded in 1998. This is a formal agreement, very similar to those under Article 15a, but with one perhaps specific feature. The municipalities are normally not allowed to conclude agreements under 15a, but they were constitutionally empowered to sign this very agreement on the consultation mechanism. And now this consultation mechanism says that when the federal government or the lender plan to enact a law or a regulation that would have financial impact on the other levels, they would have to pay additional costs. Then the level that wants to enact this measure will have to inform the others at a very early stage. And if one level complains of that intended measure, a consultation committee will have to be convened. And this committee consists of representatives of all three levels, they are on equal terms, and they will have to discuss the intended measure, and if they don't find a compromise, the level that wants to enact this law or regulation will have to bear the costs itself. And the interesting thing is that although the consultation mechanism has been applied from time to time, another quite informal practice has developed at the same time in order to avoid the very formality of the consultation mechanism. All three tiers have developed a very informal practice to consult even earlier to that, to inform at an even earlier stage than would be necessary under the consultation mechanism, to consult with each other very informally, reach a compromise, and then nobody speaks of the consultation mechanism at all. However, there was a case 5 years ago when the municipalities complained of a violation of that mechanism by the federal government. They went to the Constitutional Court, which they may do in this case, and the court said yes, it was violated. And it condemned the federal government for having violated it. And it would even be possible to sue before the Constitutional Court for financial damages in this case, and so on. A final fiscal instrument I would like to mention here is the Austrian Stability Pact. It has the same legal agreement nature as the aforementioned consultation mechanism. The Stability Pact tries to reach a balanced national budget that is in line with the EU convergence criteria, because of course it's always difficult in a federal system. You have different budgets at federal, land and municipal level, and how to reach a national budget that is in line with the EU criteria. Now the Stability Pact says the municipalities have to reach a balanced budget. The lender and the federation must not go beyond a certain deficit. But if one party violates this, for example, produces a bigger deficit than it may, there will be a sanction committee. And again, the sanction committee consists of representatives of all three levels. They negotiate on equal terms, they try to find a compromise, but if not, the sanction committee will condemn the violating unit to pay damages as long as its deficit doesn't improve. Now, let me finally add that apart from all these constitutional instruments, there are also extra constitutional instruments that play a very important role in the out-of-court management of litigation in Austria. This is not only the so-called liaison office of the lender, which is located in Vienna. It's just an important but absolutely informal bureaucratic apparatus of the lender that assists the lender and their cooperation, their intergovernmental relations. But what is more important is that a couple of informal conferences exist, either mixed conferences, federal, lender, municipalities that are represented here, for example, the council that is required for consultation on EU and foreign affairs, but more important, a number of lender conferences. For example, the Conference of Lender Governors, the Conference of other members of lender governments, the Conference of Presidents of the lender parliaments, conferences of senior civil servants of the lender that meet several times a year, and mostly the federal government delegates one observer that attends these meetings, perhaps says something, but of course has no vote in these lender conferences. And the most important of these is the Conference of Lender Governors, the 9 governors of the lender that meet several times a year, just a few days ago, for example, in Carinthia. And they have truly been called the power in the shadow, because the conference is really powerful. It is politically much more powerful than the formal federal council, the federal second chamber. It is extremely powerful, although it doesn't have any formal legal basis at all. They just assemble and discuss things. But then they represent the attitude towards the federal government, and usually this has some effect in Austria. If they reach no unanimous decision, they will not present any position at all. So it's either unanimity or nothing. But there have been cases, and this is interesting, where governors belonging to one political party do not follow their own central party politics because they rather stick to the Länder attitude. So that's interesting. For example, one governor, a social democrat in one land, has in recent years frequently not followed the central social democrat party line. But there are also conservative governors, especially in the Western Austrian Länder, that founded some years ago a so-called Western Axis. It was called, a bit ridiculous, by the way. But they do not always follow the party line of the Conservative Party. I won't speak about the recent crisis because everything may be now a bit different, but normally I say. For example, some weeks ago, a federal framework law for a minimum social income was presented by the federal government and its conservative chancellor, and still some conservative governors in the Länder said we are not really satisfied with that new federal framework law. So normally they discuss things, they negotiate things, and normally, even if it takes some time, they will reach some compromise also with the federal government as a rule. Now, allow me to conclude very quickly, very briefly. I think at a first glance, it may seem that the out-of-court management of litigation in Austria is quite political, quite informal. But I think that the Constitutional Court is something as an invisible or hidden partner in the whole issue, because either the court plays a role at the beginning when it comes to the pre-legislative scrutiny, or because the court threatens at the end of a certain process because the parties know it is possible to go to the court, and because the court has developed some principles, as mentioned before, that can be used as a more general abstract yardstick. And I would say, perhaps quite paradoxically, that the Constitutional Court, when it comes to dealing with intergovernmental disputes, has perhaps a more political attitude, perhaps a more legal political attitude than in other contexts, because normally the court is much more positivistic, much more dogmatic in other issues, rather follows the Kelsenian style, of positive law and so on. But not so in this arena. So perhaps the court is a bit more political in this context. So the paradoxical statement with which I would like to end is perhaps that the out-of-court management has a hidden judicial or legal nature, but what the Constitutional Court does in this context has a more political nature. Thank you very much.
Well, thank you very much, Anna. You gave such a broad picture, and it is amazing, I would say, how constitutional systems take one particular track with or without formal rules. We have seen the case of Switzerland. I understand I have the privilege of having been the first constitutionalist that Eva Maria heard talking about Article 44 of the Swiss Constitution. And in Austria, there is no equivalent to Article 44, but you have a number of explicit or implicit principles, and in particular, you have, if I may, an understanding of federalism, which is very important. It is the understanding of federalism as a process which does require adjustment. Some 40 years ago, perhaps, the well-known journal Publius described the existence of, if I remember correctly, 44 different varieties of federalism. One of them was the spaghetti federalism, and for some reason I thought it was not a very appreciative label. But today we heard that there is also the torpedo federalism, and which is almost a sort of shocking interpretation of federalism. But apart from any joke, I would say really that here, as Anna pointed out earlier today, history does make a difference. And so the history of Austrian federalism does provide the different actors with the proper understanding of the way the system ought to work. So this, I would say, is a great lecture coming from Anna's presentation. Also, let me just point out, perhaps this also has to do with this sort of implicit understanding, the idea of the Constitutional Court being an implicit partner. Now, of course, I'm not an economist, but I think all of us know about the invisible hand that should guide the regulation of the market even without laws and the like. Well, in my own understanding, the Constitutional Court is a much more tangible, invisible hand than the one that has been recalled by economists. So thank you very much. We have another very interesting presentation, and I'm sure the same we could say with the following presentation by Karl-Peter Sommermann, who has been a guest in this law faculty a number of times. So I'm very glad to give you again the welcome here. He's from the very well-known German University of Administrative Sciences, or I thought it was Academy, wasn't it?
University.
Oh, University.
Postgraduate.
All right, of Administrative Sciences in Speyer. And we heard so much about important federalism, but perhaps now we have the big brother, which is German federalism. So, Karl-Peter, you have the floor.
Yeah. Thank you very much. I'm very pleased to be here again, and above all, Professor Tognatti has found really a very interesting topic, which I do not find very often in the discussion, but it's worthwhile as we hear today. So it's an extreme pleasure to participate here. What I will have to say about extrajudicial settlement of conflicts between federation and Länder, we have the same term, Länder, it means federate states, so don't be confused when I say Länder, it's not something where you will ask, it's a federate state like in Austria. When I talk about this, just to say, following to what we heard, it's a subject which is extremely linked also to constitutional culture and political culture, we heard. The historical experiences are inside. Then we saw also that, as you said, living instrument, that means federalism is always moving. It changes over time in all our countries. And the same is true for the decentralization, and like in the case of Belgium, decentralization goes even to federalism, which is very interesting if we consider the original definition that only when states come together, they form a federation. But we should also perhaps forget all these old categorizations. No? Federalism is perhaps the better categorization also in the Belgium case nowadays. I will shortly give you context. Most of you know German federalism quite well, so please forgive me that I will make some explanations just to bring everybody to the main information about the system in order to understand also the mechanisms of extrajudicial resolution. After these first introductory remarks on German federalism, I will then turn to the question, are there formalized procedure for the settlement of conflicts? Then I will talk about solutions by participation and negotiation. And we heard many examples today, Austria, Switzerland above all. And finally, I will also touch upon the question, are there hierarchical solutions? In a federation, a strong federation, often you have also hierarchical instruments. We saw it lately in Spain, how far this can go. And I will end with a short conclusion. So my 5 preliminary remarks. First of all, Germany is a federal state. That means traditionally you have 2 state levels. You have the federation as a state, and then you have a second level, and these Länder are states. But this is only the definition of the constitution. It's in the national law sense. The states of second level, of course, are no states in the sense of public international law. They are lacking this independence in international relations. And in Germany, it is even now disputed if we can really speak of states. Are these not more functional unities? Is state really the right connotation for these units? The traditional vision will stick to this, but younger lawyers are defending a different position. What does it mean that they are states? The Constitutional Court says they must stay with substantial competences. It means the scope of competences cannot be reduced arbitrarily. There must remain substantial competences with the lender, and they must have a proper and sufficient financial basis. These are, let's say, 2 main yardsticks for this German federalism. Second remark. The competences of the federation on the one hand and the federation of the lender on the other hand in Germany is not distributed like in the United States in the sense of a dual federalism, where legislative competences correspond also to the administrative competences, or let's say executive competences. But this is very different. It makes it confusing if you come to Germany. So we have normally the main, according to the wording of the Constitution, the main competences with the lender. It means only to the extent that federal competences are explicitly enshrined in the Constitution, the federation is competent. And all the rest goes with the lender. But what does this mean in practice? It's a bit different. In legislative competence aspect, the federation, as you can see from the enumeration in the Constitution, has very huge competences. There's only very few which is left for the lender. Above all in police law, education, culture in general, local government law, all this is still with the lender, and certain other small subject areas such as, for example, the law on public officials as far as they are members in the civil service of the lender. So a preponderation strong for power of the federation. But now what happens with the administrative competence? Here, the lender have really most of the competences because the lender in Germany are executing, are administering the federal laws like their own laws. So for them it doesn't make a difference if they execute a federal law or a land law. They are determining normally the procedure and the organization, but the Constitution, of course, allows for fixing also, with the consent of the chamber of the lender, also procedural and organizational aspects. Would be too complicated to tell you all the little things. Just take it like that. Generally, the lender are determining the execution. And so we can say legislation, above all with the federation, and the execution by the lender. This is one of the elements why we say we have an executive federalism. Third observation. The lender are represented at federal level by the Bundesrat. They take part in the legislative process. But we do not follow a Senate model. We do not have in this Bundesrat, you translate it as Federal Council, no? It's the same name like in Austria. We do not have members elected by the people. We have members of the land governments. This is an old tradition of the 19th century when the, let's say, the monarchs of the different Länder represented their territories at federal level. Look at the Constitution of 1871 or the one already of 1867. So this remains, and we might say, is this outdated, is a kind of atavism? there are some good arguments in favor, some rationality. Because the governments, as I told you, are representatives also of this executive federalism. They have to execute the laws later. They have to deal with them. So it's perhaps quite reasonable to include them already in the making of these laws in order also to consider aspects which might be important for the implementation. This is at least one argument in favor, and therefore, for the time being, there is no real discussion to abolish this kind of system. Fourth consideration, the Federal Constitutional Court has derived from the federal principle, the principle of federal loyalty. We heard this already in the case of Switzerland, Belgium, of Austria. This federal loyalty, we have it also in the European Union. We have also the principle of loyalty in Spain, la lealtad de las comunidades autónomas. So this seems to be a core principle for each decentralized or federal system. If we do not have that, the state may may be blown up. What does it mean? This means really that even if you have instruments of hierarchical nature, you do not use them as federation, for example, before you tried to reach a consensual solution. It also means to consider the aspect. Somebody said, I think it was about Switzerland, the obligation to consider the different aspects. All this is included, and this principle is applied as directly applicable law by our Federal Constitutional Court. Later on, I will give you one example about that. So that's not a mere programmatic principle, which might be nice, but does not have interest in practice. So conflicts, from this derives the principle, conflicts should be resolved in mutual consent. This is always to be the first step. Duty to communicate, all what we heard is also enshrined here, although in Germany we are perhaps not with such intensity in this communication approach as Switzerland is for historical reasons. Fifth and last observation, structural, perhaps I take this might perhaps even be better because it has a, yeah. Clearly in the microphone. I will speak in the microphone. If I speak clearly is another question. So my fifth remark, structural problems which have arisen among federation and Länder have been resolved in the past by very important constitutional reforms. Normally these reforms, they need a 2/3 majority in both chambers, have been done in great coalitions. But you had some big parties which together formed, let's say, the basis for the government, and they had the necessary majority. That's why we can say we had a lot of reform, and our federalism was always adapted. If structural problems arose, then we were lucky to have situations which could be reformed, a bit different to Spain, where you do not have any constitutional reform already for a long time. But now it will certainly work. But perhaps this helped us not to let develop too much gap between reality and conflicts and the law. So we had our first very important reform in 1969, which enabled Länder and federation to cooperate in a stronger way. Partly this reform only adapted the law to the legal reality because it had already started this kind of cooperation, and this was sanctioned afterwards, not sanctioned in the sense of sanctioned, it was, let's say, legalized in a way. And then, long time not such a very important, during the last 15 years we had 4 reforms which were very important. First one, 2006, there was a new arrangement of competences between Länder and federation, and one of the main objectives was to reduce the number of laws that need consent by the Bundesrat. Consent by the Bundesrat means if you have other political majorities in the Bundesrat, the second chamber, as in the first chamber, this might lead to a blockade, to a block. This is the Politikverflechtungsfalle, the trap of Fritz Schaff created this term that we are living in a state where the interrelations lead sometimes to dysfunctional results. And this reform from 2006 should then reduce the number of consent-dependent laws, and in practice we can say it worked. Before we had nearly 50%, and nowadays it's said more or less 30% of the laws are now still consent laws. I can explain you more what this is if you like later. 2009, new deficit rules, like in many other countries. The balanced budget amendment, we heard already of it in Austria. Also the balanced budget amendment, Schuldenbremse, or debt brake, that is a very good instrument for the Minister of Finance to say no more money to spend. That makes his task easier. And then 2017, very important, a new arrangement of federal and Länder finances. The system of financial compensation. You spoke about financial equalization. In Germany, this would be a bit problematic to speak of equalization because our constitutional court said there is a prohibition of Nivellierung, of equalizing, Nivellierungsverbot.
Leveling.
Of leveling, of total leveling. So I prefer the term for Germany, the compensation system had been changed. And this is very interesting because by this constitutional reform, a very fierce conflict was resolved because the two Länder, Bavaria and Hessen, had sued a file before the Constitutional Court against the system of compensation because they said we pay too much. We are weakened by the system and this is not possible, this is unconstitutional. The German compensatory system provided for first a horizontal compensation, that means among the Länder a certain kind of balancing of financial means, and then vertical between federation Länder again. Quite complicated system in 4 steps, and this is has now changed. Now we do not have any longer the horizontal compensation. We have now everything by vertical approach. It means one part of the different financial power of the Länder is equalized, if you like, by the part which the Umsatzsteuer, the taxe à valeur additionnelle, VAT, yeah? But this is one of the means to equalize, and the second one are financial contributions of the federation to these Länder. I think in the end there's no difference because the money comes from anywhere. But we are out of this problem between the different Länder, between the rich and the poor Länder. So this is quite tricky solution. You may calculate if this makes any difference. At least it was good for the two governments of Bavaria and Hessen to withdraw their action from the Constitutional Court. Then the last reform comes from March of this year, 2019. This strengthened again the possibility of the federation to take part in the financiation of infrastructure at local level. Infrastructure, educational infrastructure is explicitly mentioned in this law. This means the federation cannot give money immediately to the local government, so it gives the money to the Länder, but these are obliged to take this money in order to strengthen the infrastructure in the educational sphere. And there has already been elaborated agreement between Federation and Länder about the digital infrastructure in the schools of the municipalities. Normally the municipalities have to pay for the infrastructure, and they will get now money in order to foster the German development of digitalization. You know, Germany is a very bad place in the comparison of the Commission, the European Commission in Brussels. We can read that Germany is, I think, at the 15th place, something like that. All other states are better. Romania is better than Germany in digitalization. And now we are trying to catch up. And therefore, here, this mechanism makes it possible that Germany also becomes digitalized. I hope not too much. So this is underway. And these were my first remarks on the, let's say, situation of federalism. Now I want to ask, as I said, are there institutional mechanisms of extrajudicial settlement of disputes? First of all, in our constitution, you will not find any clause on arbitration or mediation. Mediation in the long sense. We have a small mediation process I will mention afterwards, but not as a general system. For the disputes, then, we have, of course, before the Federal Constitutional Court, that means there is a judicial means, which is the conflict between federation and Länder. And this is a special procedure which has been established with our Constitutional Court. And only to tell you, that does not have many importance. We had, over the years, since the 50s, 46 procedures. And during the last 10 years, 2 procedures between federation and Länder, according to this procedure. You see, this practically, it does not have big importance. And you have to compare this with the 230,000 cases in constitutional complaints, which had been introduced in the same time in the Constitutional Court. 230,000 constitutional complaints. It may be that in this constitutional complaint, as well as in the control of norms, there we have about 3,500 concrete norm controls. It might be that federalist aspects have played a role in this, because if you are attacking a law which violates, you say it violates my fundamental right, the court will check also the competence of the federation, for example, if it's a federal law, or the competence of the land, and so on. That means if we would really do research, we would also have to look in which judgment perhaps aspects of federalism had been introduced. To this point, only my conclusion, only the formalized procedure, which has been specially done for that, does not play a great role. Now the point, solutions by participation and negotiation. We can first of all see that the drafters of the Constitution and the subsequent constitutional practice have created several instruments that serve to avoid, to prevent, or to resolve conflicts between federation and Länder. I just want to mention these 3 instruments. As far as the constitutionally established institutional framework is concerned, the participation of the Länder through the Bundesrat, the Federal Council, in the federal legislation contributes to prevent conflicts. It's a bit different, perhaps, as the role of the Bundesrat in Austria, but you mentioned. In Germany, I would say it's a quite strong role which it plays, because if the Bundesrat does, the Bundesrat where you have the representation of the Länder governments, if they object a bill which has been passed from the Bundestag, the parliament, to the Bundesrat, they can object this, or they can even reject the consent if it is a consent law. This is defined in the Constitution. However, what has to be done first? If they want to object, they have to call upon the mediation committee. The mediation committee tries to find a common solution between both chambers. And this mediation committee, Vermittlungsausschuss, is composed by 16 members, 8 from the Bundestag and 8 from the Bundesrat. And the outcome of this Commission is quite productive. Normally, or very often, they find solution. If you want, this is a kind of mediation procedure, but normally for mediation you need one mediator who is not present there. They have to mediate themselves in this committee. There are several constitutional judgments on this mediation committee, but not concerning the mediation between federation and Länder. It's more about the 8 members of Bundestag, because there are often parties who say, we are not represented in this mediation. 8 persons only, and me, belonging to a minority in the Bundestag, I'm not here. So this works even though you find these judgments, but they refer to other aspects of it. The Bundesrat, so, is a constant organ, we have to say. There are no elections to the Bundesrat, but the composition changes. With the changes of land government, new representatives will be sent, and this means that the majorities can switch from one to the other and perhaps even produce certain veto powers of this Bundesrat. And therefore, the Bundesrat is a good example, what you already mentioned, of this interdependence trap, or let's say the trap of joint decision. Yeah, I think it's not, I cannot translate it. Politikverflechtung. Verflechtung means interdependence, interrelation, entanglement, yeah, all this. And the trap is, if you fall in this trap, you will have one player who does not act with you, and so you can forget the project. And therefore, this is an old discussion in Germany since the 70s, how to avoid this trap, how to make more the organs accountable and to know exactly who is responsible for it. Second point, cooperation in standing conferences. We have, as we heard also for Austria, conferences of specialized ministers, also from the prime ministers, and there is done a very important work which also avoids conflicts. This is quite strange because these conferences normally are an instrument of self-coordination of the Länder in the horizontal affair. But there are also representatives of the federal government in it, and they have the right to initiate something, but they do not have the right to vote, as in Austria. But I think this enables this steady communication, which avoids conflicts, though it's a very important area. And then, last instrument, treaties, administrative agreements, and instrument of open coordination. What are treaties? In Germany, we call treaties, which are, for example, concluded between the different Länder or the Länder and the federation, on the field of subject areas which need normally regulation by parliamentary law. In Germany, we have quite strong criteria which subject has to be regulated by the democratic parliamentary representative themselves. All important decisions go to them. And then the minor decisions, for example, administrative issues, can be concluded immediately by the executive power. Treaties then are a bit more important. I give an example. There is a treaty on the joint tasks of federation and Länder in the field of research. By this treaty, the federation gives quite a lot of money to make possible also extra university research. We have 4 big societies, research societies in Germany. This is regulated by a treaty. Administrative agreement, it was this digital agreement which I mentioned. This, for example, can be done in form of an executive agreement. And then I mentioned instruments of open coordination, or should I say perhaps political agreement. I give one example from the year 1957, which is very important still today, and a bit opened up the new perspective in our federalism. It's the so-called Lindauer Abkommen, the Agreement of Lindau. What was the background? The background was that the Länder contested the competence of the federation to conclude treaties which would touch upon their exclusive competences. And on the other hand, the federation said, we have treaty-making power according to Article 32, and if we have treaty-making power, we have also the power then to transpose the treaties into national law. So there were 2 different positions, legal positions. But it was clear there should be any solution. And what did they do? They make a gentleman's agreement, if you like, saying this is a modus vivendi. The federation will have the duty to consult the lender, to make them participate before they conclude a treaty, and then the lender later will also stick to the obligations which had been created by this federal treaty. This is a very brief from. So I think this was a model which showed a way to a consensual approach in resolving conflicts. Very brief, my time is already over, but very short. What are hierarchical solutions? I showed up to now.
3 minutes.
I have still 3 minutes? Ah, wonderful. This is, I think, exactly what I need. Hierarchical solutions. The other things were consensual, negotiation, trying to get to consensus in different arenas. And here, but the Grundgesetz, our basic law, provided for very traditional instruments of hierarchy. For example, when the lender execute federal laws, I told you they do it as if these were their own laws. Nevertheless, Article 84 provides for the possibility or for the necessity even of supervision in the legal sense. So if the federation is, or the respective ministry is of the opinion that the land does not apply the law as it should, it can tell this to the land and they have to reconsider their position. And they're even under very severe preconditions is also the possibility that one minister of the land then instructs immediately the ministry of the land. But this, I think, never happened in this context. In another context, yes, because we have a very strange kind of execution of land, of federal laws. I'm very sorry, it's quite complicated. It refers to the execution of federal laws by the lender on federal commission, Bundesauftragsverwaltung, which is a very complicated thing in only specific subject areas. An example, atomic energy, building of airports, and so on. Here, the federation has the right to order that this is done by commission of the federation. This means that the federation in this sense has the power to instruct authorities of the highest authorities of the lender to act on their behalf. You might say, what is the difference? The difference is really that normally there's no way to instruct lender administration, very rare exceptions. And the use in this context, it was about atomic energy. It was about granting a permit to construct a nuclear plant. Yeah? And it was in the 80s, and we had a green government in Hessen, and they didn't grant the permit, although the legal preconditions had been complied with. Then the federation started conversation, and the land government did not react, and finally the federation instructed now to grant the permit. The land then made a Bund-Länder-Streit, that means a conflict before Constitutional Court, saying that this instruction was not in compliance with the Constitution. And in this very important judgment, the Federal Constitutional Court first emphasized the principle of cooperation. So the federation has to do everything before taking such instructions. But on the other hand, once it takes the instructions after these preliminary proceedings, then there is no way for the land government to say for other legal reasons they cannot do it. If there's a problem, they have really to check it, perhaps even with help of the Constitutional Court. But from this time, we had nearly no problems more. This was so the Constitutional Court emphasizing the operative principle. Finally, Article 37, which had been introduced in the Spanish Constitution of 1978 in Article 155, And in the German case, this means federal execution. It means if a land fails really to comply with its fundamental obligations, the federation can intervene. In Germany, this has never been used. So we have now a first case, but in Spain, to an empirical case which we can study what happens if this is done. Yeah? It's very interesting that in the land of origin sometimes you do not use it, but in another context it is used. So to sum up, the hierarchical options are in Germany nearly never used. They are there. Maybe in the future, I don't know what will happen, but normally they are not used. Conclusion, the German federalism is also a cooperative federalism, very strong cooperative federalism, and its instruments have been developed in long historical processes. Think about the question of Bundesrat. So also the instrument to prevent conflicts have to be understood from this cooperative approach. That means also that the way to the Constitutional Court is considered to be ultima ratio, the last resort. This has been said also from somebody about the situation, I think, in Switzerland. No? This was the case. And we can also say, as you told us, that the Federal Constitutional Court, in its jurisprudence, in its case law, has always encouraged, I think you said it, encouraged really to find a friendly settlement, extrajudicial settlement. And perhaps a last point, which seems to be very important, our constitutional law has proved to be quite flexible also because we had many reforms. This is often criticized. We have more than 50 constitutional reforms. The text of our constitution is twice as long as it was in 1949. We have certain logistic problems, for sure. But it shows also that this reform from time to time also helps to avoid structural conflicts. And perhaps so there are different elements. And Chopra, you mentioned, who said conflicts better to be settled in the political process than in judicial litigation, is more or less already put into practice in our system. Thank you.
Thank you again. Once again, we find out that even without an explicit constitutional principle encouraging extrajudicial settlement of disputes, we see that, again, because of the principle of loyalty, because of the age-old federalism that you have been experiencing, we have a situation very similar to the one of other jurisdictions that have been examining so far, if nothing else from the point of view of the very low number of court cases. So this is a very enlightening. Cooperative federalism once again proves that it is somehow scattered throughout the system and not necessarily in one provision, in one committee, and the like. So thank you very much for this presentation. Peter, you have the 30 minutes that everybody has had, plus you have Brexit plus, let's put it this way, okay?
Okay. Can I have, which microphone is this?
You can also use the mobile one.
The mobile one?
Yeah.
Okay.
I think you have to switch it on. Down at the bottom.
Oh, okay.
The red light should appear.
Yeah. Hello?
Now, yes.
Hello? Can you hear me? Okay. So,
yeah. No, you only had one.
Only one. I mean, you're not going to miss anything.
So we had to turn our neck only once.
I'm just going to. I just thought it's good so you can follow my gist. Before I start, I'd just like to thank Roberto for inviting me and say how nice it is to be in Trento with friends, because we've a lot of us have met before, and the only thing I'm sorry about is Brexit, but not about being in Trento. So basically, just to put you in the picture, it is coming up. I've tried to use Brexit as a kind of case study to answer the questions that we're dealing with in a sort of way, because it has a profound effect on devolution. And I'm not going to deal with all that, obviously. I'm only going to deal with certain aspects of it. I'm going to start off by just saying one or two things about multi-layered governance and about the political situation, making a contrast between before and after devolution. Then I'm going to say something about the core concept of sovereignty and how legal sovereignty is supposed to work under the UK Constitution. But of course, one of the aspects of devolution which is really important and which is affected by Brexit is the so-called Sewell Convention, and I need to say something about that. And then we have, because of the Sewell Convention almost, we've had this interesting case to do with the Brexit bill, and this also is like an example of non-cooperation, as it were, which I'm going to pick up on. And then I'm going to finish by talking about things which are really similar to what Carl Peter has been talking about just now, which are things like concordats and agreements. So that's the program, and I'll just leave that there for you to see. Let me start by saying that this idea, we've heard a lot about multi-leveled governance, and obviously that's central. I would like to say that when I sort of dealt with this subject, we've talked about multi-layered, and that is a sort of variation on this theme because it's to do with the different levels of government, but also, and these levels of government we would consider to be not just the finite levels at a statutory, in a statutory sense of devolved government, local government, central government, and EU government, and so on, but also the soft law elements, including things as far as Northern Ireland is concerned, which I'm not going to talk about today, the North-South Ministerial Council, the British-Irish Council, but also these concordats and agreements which are associated with devolution. The multi-layered governance takes account of the interaction between government and governance. That is to say, the public, private, the contractual, state, and all of that thing. Obviously, I'm not going to talk in any detail about that, but I just wanted to mention and be specific about qualifying what I'm talking about when I talk about multi-layered governance. Now, to move on to the political context, it's quite an interesting thing. I mean, Justin and I were talking about 20 years ago since devolution was introduced. Well, a lot of water has flowed under the bridge, as they say, since devolution was introduced. If we go back 20 years, the Blair government was freshly elected. Devolution was its flagship, or one of its flagship policies. And this sort of brave new world was all to do with rejecting centralisation. Centralisation of 18 years of Thatcher and Major and all of that from a political point of view. And it's interesting to remember that for almost 10 years, Labour were rampant. They won huge majorities in Parliament. And the other thing which is interesting to note, and this is something that's come up in other discussions on as far as devolution is concerned, is that Labour were also in the ascendant in both Scotland and Wales. So the politics had a certain consistency across the United Kingdom. Northern Ireland's a different case. I'm not talking about Northern Ireland, but when we talk about devolution, and so when we talk about all of the buzzwords of New Labour, modernising government and governance and all of that, that was something that was a sort of commonality across the United Kingdom. There were some differences. It was always true that Scottish Labour were to the left, as people would have said, with certain policies looking after the elderly and student fees and so on. But the point is that Labour dominated both at Westminster and at devolved level. And I mention this because if we just look forward to what's happening now, this is all a distant memory. We have a lame duck, I would say, Conservative government as we're talking, which was supposed to have an overall majority after the 2017 election, which it doesn't have. I mean, and that depended on the DUP supporting the Conservatives. So we don't have a situation where any party has a majority in Parliament, which is unprecedented in recent times. And the Conservatives, Labour is an altogether different party. Some people say it's a more extreme party, a less tolerant party. The Lib Democrats have virtually disappeared, and we have a big representation of nationalists, and of course on the fringes, not really in Parliament, we have Farage and the UKIP and all of that kind of thing, the anti-European parties. So at the same time, devolution has changed. We heard about living, we use the word living federalism. Well, devolution has moved on, I would say, even more quickly. I mean, we've had a large amount of legislation. We had the referendum in 2014 to do with Scottish independence, and although it didn't bring in independence, it brought with it a bill which became the Scotland Act of 2016, which consolidated a large degree of financial autonomy for Scotland. And incidentally, and again, I'm not going to talk about this, but this has profound implications because the so-called Barnett formula and all of that kind of thing is modified necessarily as a result of all that, and that has an effect on devolution. And there has also been legislation as far as Wales is concerned, and now Wales has legislative powers and all of that. So, so as Brexit gets underway, we also need to take account of the fact that Scotland voted very strongly in favour of Remain, Wales voted narrowly in favour of Brexit, and Northern Ireland voted in favour of Remain. I mention those points because this sort of frames the argument. Now, the thing about devolution, which marks it according to, I mean, it's a very crude distinction, but nevertheless it's a useful distinction. The thing that makes it different is that sovereignty was retained as part of devolution. And I mention this because there are very strong safeguards in place. Now, we heard about, Anna was talking about pre-legislative and post-legislative scrutiny. Well, that is all written into the legislation as far as devolution is concerned, both for Wales, Scotland, and Northern Ireland, all of that kind of thing. So the first stage, as far as legislation is concerned, and as far as the powers being exercised by at the devolved level of government is concerned, it involves the presiding officer and law officers scrutinising legislation in depth to make sure that it remains within the powers that is supposed to be granted. And this has been very important as far as devolution is concerned. The legislation itself sets out the limits of those powers very clearly, also with interpretive guidelines as far as how they're supposed to be exercised. And I actually came across a quote by the Supreme Court in this recent case, where they were quoting Lord Hope in another case, who said, disputes between the Scottish Parliament and the UK Parliament as to legislative competence have been avoided partly by the use of legislative consent motions passed by the Scottish Parliament, and partly by the care which officials within the Scottish Parliament have taken to ensure that measures which the Scottish Parliament passes are within competence. Now, of course, this is referring to Scotland, but actually I could say very much the same thing as far as Wales and Northern Ireland is concerned.
How about national legislation? Is there any preventive scrutiny over national legislation?
No, this is only, we're talking about the legislation introduced within the Welsh Assembly, yes, the Northern Ireland Assembly, which isn't functioning at the moment, and the Scottish Parliament. Right. I'm not talking at all about national, at the national level. So this brings us to the role of the Supreme Court, which I just want to say a little bit about. The devolution legislation, although it introduces these elaborate mechanisms to prevent legislation from going beyond the competence, also introduces the possibility of devolution issues. And these are to do with questions relating to the functions of the legislatures and governments, which were established as part of the devolution arrangements. And they could be taken, they can be taken at an official level or at the level of interested citizens or whatever. But there have been rather few of these cases involved in as far as cases brought before the court. Interestingly, the original cases, nearly all of them, were to do with the Human Rights Act, because some of the early legislation which was brought before the Scottish Parliament and so on, were to do with things like appointing sheriffs in the Scottish courts, and they were challenged on the basis that the procedure was in breach of Article 6 and that kind of thing. But otherwise, there have been remarkably few cases, but there have been some, and one I want to draw particular attention to, which is the AXA case. Now, the AXA case was a very significant case because it involved a direct challenge to a piece of legislation which had already been passed by the Scottish Parliament. And it was actually challenged on a number of, it was challenged under the Human Rights Act, but it was also challenged by way of judicial review, because the idea was that it was ultra vires the Scotland Act of 1998, because it went beyond the competence of the Act. And this challenge failed. But what was interesting is what the judges had to say about it. And I've got two quotes. Lord Hope again, who was he was a vice president of the court, he said that in principle, acts of the Scottish Parliament are subject to judicial review, but at the same time it would be wrong for judges to substitute their views on these issues that are for the considered judgment of a democratically elected legislature. And he went on to say that therefore the threshold would be extremely high. Another judge, Lord Reid, in the same case, said that it wasn't possible to challenge the legislation, and judicial review certainly wouldn't be available under common law grounds, as this was not foreseen by Parliament enacting the original devolution legislation. It would be confined to extreme cases, and there's a resonance with what you were saying about, last resort challenge, and no such case has arisen. But it gave examples of challenges to the foundations of democracy, removing voting rights, taking away fundamental human rights, that kind of thing. So what we can say about this is that there is a very high threshold which is set up to prevent direct challenges. But of course, then we come to my next topic, which is, I think we're on to number 3. I've called it in my paper, consultation, cooperation, and the Sewell Convention. And the reason that the Sewell Convention is important is because, of course, in the United Kingdom, we don't have a codified constitution. So the devolution legislation has been described as being equivalent to constitutions for Scotland, Wales and Northern Ireland, with the added extra legislation as it was passed, obviously being of great importance. So legislative consent motions, now what are these about? Well, they come into play as an important part of devolution when there is an overlap between the power, which is something we've been hearing a lot about just now with the federal systems, both of you talking about this, and I also Ava, where there is legislative overlap between the power of the Westminster Parliament to legislate and the power of the devolved legislature to legislate. The point about this is that there's an assumption of consultation here. And this convention, I would argue, has been very crucial to what I call the spirit of devolution, because it recognizes the need for cooperation, which again is something else which has been resonant in our discussion today between the levels of government. Now, Brexit, of course, has a direct impact on devolution, as a substantial body of EU law relates to functions that have been devolved. And in particular, the withdrawal legislation deals with transferred matters, makes changes to the powers of devolved ministers and of the devolved legislatures. In other words, leaving the European Union would affect the scope of devolved matters. Without further legislation, it would enlarge them, because the devolved legislatures would no longer be constrained by European Union law in relation to these transferred matters. So given that the withdrawal bill, which came in 2017 and is now in the Act, transposes EU law on these devolved matters, the legislation obviously required a legislative consent motion. So this protocol between parliaments requires consultation. This is the important point. And the consultation within the context of the first few years of devolution worked rather well, as you would perhaps expect. So the overlapping, where you have overlapping legislation, there were quite a number of legislative consent motions. I mean, there was a very good book written about this, in fact, by Robert Hazel and Rick Rawlings when devolution first came out, in which they talked about particularly the use. Well, it was an edited book, but there were a number of essays on this topic, which was very interesting. Now, the reason that I come to this is that then we have Brexit, and Brexit throws this up in the air as a big issue. When they had the Miller case, if you remember, when we had the referendum back in 2016, Mrs. Miller contested the right of the British Prime Minister to trigger Brexit using the prerogative power rather than going through Parliament and using a statute. Now, as part of that case, there was a referral through Northern Ireland and the devolved parliaments to the Supreme Court on the question of the Sewell Convention. And this is quite an interesting point, which I'm not going to go into in any detail here, but I just want to mention the argument that was presented was that this was so important, this convention, that it was actually written into the Scotland Act of 2016. So that it wasn't just like a convention as originally recognised as a parliamentary answer to a question to Lord Sewell during the discussion of the original devolution legislation. Here it was written into the Scotland Act of 2016. So the devolved legislatures said, by the way, we would like a ruling by the Supreme Court on this question, whether this really is a convention in the normal way, or whether it's legally enforceable. And the Supreme Court, very disappointingly, took a very traditional constitutional view on defining conventions as being not enforceable in the courts, notwithstanding the fact that it had been written into the legislation. And in this paper, I incidentally object to this interpretation for a number of reasons, but I don't want to go into that now. I wanted just to say it is acknowledged that there are dangers in moving to the over-reliance on courts to resolve political questions, or indeed to expect the courts to generally enforce constitutional conventions. Post-devolution, there was a formal retention of overall legislative sovereignty as a last resort in the hands of the Westminster Parliament. However, the Sewell Convention, requiring legislative consent motions to be granted, has assumed a special status. It was intended as an integral part of devolution, and it's now recognised, as I've said, in statutory form. And it embodies the spirit of devolution because it provides a formal channel of consultation between the different levels of government. So it's particularly important. If the Westminster government, as it has, simply ignores the need for legislative consent motions because they may be inconvenient in the light of the sensitivity of the subject matter, it gives the Westminster government, and not Parliament, the right to set the limits on devolution when it suits it to do so. Such an approach undermines a crucial part of the established constitutional framework. And so this issue of the Sewell Convention, I think, is a crucial thing. And this leads me to the next point, because we have a practical example of this almost immediately. Because when the government, after the 2017 general election, reintroduced the Withdrawal Act, the EU Brexit Withdrawal Act, it's now called, well, now I'll forget what it's called, but it's basically let's just say it's the Withdrawal Act. It's something like that, anyway. So what they did was the government wanted initially to get approval for this act, and they sought a Sewell motion, a legislative consent motion, to get approval. Of course, they didn't get it because of reasons which I'll mention just at the end of the presentation. But then what happened was that the Scottish Parliament decided, okay then, if you're not going to take any notice of what we want put into this Withdrawal Act, what we'll do is we will introduce in parallel our own legislation, which will allow the Scottish government to selectively decide what to keep and what not to keep as far as EU law is concerned. And the argument that they used was quite a clever one, because they tried to use the argument that although EU matters were excluded from the competence under the Scotland Act, this Act would only come into force after Brexit, so that it would no longer be EU, it would be retained law. Do you see what do you see the argument? So that was the kind of argument that was being used in trying to contest the legislation, which was all very interesting. So this bill was being introduced into the Scottish Parliament, and it was duly introduced and debated. And then when it came to being sent for the royal assent, which is part of the pre-legislative process, so it demonstrates the whole process which I've been described, the law officers of the Westminster Parliament, the representing the law officers who are delegated under the Scotland Act to scrutinise the bill, let's just say, they contested the bill as being outside of competence. Now, the interesting point here, and this is again relevant to our discussion today, this is the first time ever that any Scottish bill has been contested. So you're talking about, Ava was talking about how few Swiss, and you've got 230,000. I mean, there's so many differences in terms of the numbers of things, but here this is the only contestation that we have of a bill before it's hit the statute book. Obviously, the AXA case, which I mentioned earlier, was after the thing had been already legislated. That was contested afterwards. So this was referred to the UK Supreme Court. And this is, again, quite an interesting thing, because this, according to, Lady Hale has lectured about this and so on, this is a kind of abstract review because the thing hasn't actually become a law yet. So here we are in new territory as far as the UK, although there have been some Welsh legislation which has been contested. But I don't want to go into too much detail on this. Anyway, the position of the Scottish government, as I've just said, was that the bill fell within its competence as it would already have left the EU. And the House of Lords, the Supreme Court, I'm really out of date now. I've gone back 20 years myself when I'm mentioning the House of Lords. I'm really not thinking about it because, of course, the House of Lords was abolished in 2009. So it shows that my brain stopped then. Anyway, let's hope that I can restart it. So the Scottish government, the Supreme Court recognised in making their judgment, in fact, that the Scottish Parliament had the power to legislate in general. And part of this is interesting because it reflects something which I said right at the beginning, which is this scope for policy divergence. The Supreme Court was careful to recognise the distinction between constitutional restraint on the one hand and policy choice that lies behind the devolution settlement on the other. In relation to the application of Schedule 5, the distinction between the power to legislate, a strictly reserved matter on the one hand, and the policy therein contained, which is not, is crucial. The powers of the Scottish Parliament, like those of parliaments in many other constitutional democracies, are delimited by law. The Scottish Parliament is democratically elected legislature with a mandate to make laws for people in Scotland. It has plenary powers within the limits of its legislative competence. So in principle, they said that basic argument, which I gave you at the beginning, about the fact that being outside of competence, that they have the power to legislate about matters that were formerly part of EU law post-Brexit. However, the Act had, unfortunately for the Scottish Parliament, another clause in it, which was Section 17, which was an altogether different thing, a different kettle of fish, because under Section 17, the Scottish Bill, subordinate legislation, obviously that's delegated legislation or secondary legislation, made by UK ministers post-withdrawal, would have fallen within the legislative competence of the Scottish Parliament. And this meant that the presumption under the Scottish Bill would be that any subordinate legislation could, in principle, simply be disapplied by Scotland, and that there would have to be an active intervention by the Westminster government to prevent that happening. And the Supreme Court, on this point, decided against the Scottish Parliament. They decided, according to the law officers, the effect of Section 17 was that it would prevent the Supreme Court held, I've just read the wrong bit. The Supreme Court held that an enactment of the Scottish Parliament which prevented subordinate legislation from the UK Parliament from having legal effect would limit powers of the UK Parliament. The effect would be to modify the Scotland Act of 1998, Section 28(7), which gives the UK Parliament unqualified legislative power. So that was deemed to be beyond the competence. Now, interestingly, that what's happened to this bill is that it's just lying there. It's just been left. I mean, they after the judgment, they've sort of half won, half lost, and they haven't tried to amend it so that it would get the royal assent. So you have I've just got a few final comments before I get to the last section. How are we doing in terms of time? I've got another 10 minutes, haven't I, at least?
You do, yes.
Yes, okay. So we're doing okay. The European... I'm going to just say a few things about this in relation to the debate about Brexit at the moment. The European Withdrawal Act of 2018 constitutes, according to obviously the Scottish nationalists, you would expect them to say this, an aggressive reinvigoration of parliamentary sovereignty. And this is obviously, in the light of this judgment, we can see what that's all about. What the Scottish nationalists actually refer to as a power grab by Westminster. And this is partly because of the neglect of the legislative consent motions relating to the Withdrawal Act. And behind this, they argue, lies a trend towards centralisation again. So all of that trend that we've seen with the 2016 Scotland Act, which I mentioned earlier, is seen as being clawed back indirectly because of the Brexit process and because of the effect that that might have on EU law, which is an interesting point. But I try to balance this by saying that, on the other hand, within the confines of a traditional interpretation of legal sovereignty written into the Scottish legislation, there is an acknowledgement of the scope to legislate in policy directions at variance with Westminster. But why did the British government take this line? Well, the advantage of a consistent UK-based approach to the uncoupling process of Brexit would appear to be the main justification for the reassertion of legal sovereignty. From a practical standpoint, and from the standpoint of the Westminster government, there are manifest advantages in a common approach to Brexit across the UK. How might strong differences over the continuing protection of employment rights, for example, which is a key issue, how will that be if in Scotland workers are protected and in England they're not? Following Brexit, I mean. I'm just giving that as an example. Okay, so this is where we're at as far as this particular issue is concerned. Now, I'm going to spend the last, if I've got 5 or 10 minutes just to finish off, I want to just talk about the mechanisms that are available. When devolution was introduced, it's interesting that they looked at Commonwealth models in order to avoid dispute resolution. There's quite a lot written about this, a number of academic articles about concordats and goodness knows what, but they looked at, obviously, the mechanisms that were used were things borrowed from federal systems, including Australia and Canada. But the concordats were a number of agreements which were set up between the level of central and devolved government, or Westminster government and the devolved government. And the process of drafting the concordats, although it lacked any formal structuring, they produced something called a Memorandum of Understanding, which set a large number of general principles: good communication, information sharing, early warning of policy proposals, things that we've heard in the other presentations today. And they're mainly bilateral, but some are multilateral agreements. And funnily enough, I've done a little bit of research on this a few years ago, and I remember ringing up people within various ministries, and they rang me back, and they're very helpful. And I said, what about the concordats? It was called the Department of Constitutional Affairs. They said, oh yes, we have the concordats. I don't think that they use them, but they have them in a drawer, and if they need them, they pull them out and they look upon the terms. Now, the thing about these concordats is that they mainly happen behind closed doors. So this idea of opaqueness and confidentiality that we talked about before arises as an issue in relation to them. But I'll say just a final thing about that at the end. But the thing that's been really important as far as Brexit is concerned, and as I say, I'm trying to use Brexit as a case study, is that at a political level, where you can't resolve things through the concordats and behind these closed doors, there is a dispute resolution method, a protocol which has been agreed, and it ends up with this body which was formed as part of devolution called the Joint Ministerial Committee. And the Joint Ministerial Committee consists of the highest ranking and relevant ministers at devolved level, plus the ministers at Westminster, and at times the Prime Minister. So the point about this is that as soon as we had Brexit, and this is where I want to sort of end up, the JMC as an institution was kind of resuscitated, and there were immediate, at the first meeting, a subcommittee entitled the Joint Ministerial Committee on EU Negotiations was set up, chaired by the Secretary of State for exiting the EU, who of course is past history by now, because there have been so many resignations as far as ministers are concerned. I think it was David Davis at the time. And this was expected to meet on a monthly basis. But it's not been successful at all because of the political differences, fundamental political differences, which of course ultimately resulted in there being no legislative consent motion, which is what I was talking about when I was talking about the previous case. So I've got a quote here from Professor Rawlings, who says, "Far from, in the Prime Minister's words, full engagement with the devolved administrations, it," referring to the Joint Ministerial Committee, "has been a catalogue of political obstruction and administrative shortcomings on the part of the UK government, such that inputs by the devolved governments are the most notable by their absence." So this has led to a number of calls to completely transform the way this committee should operate. And just the recommendations, the Joint Ministerial Committee at the moment just operates on a consultative level. It has no decision-making powers. The effectiveness of the whole system is called into question because it's not working at the moment. As we've heard today, it's very difficult to envisage how any machinery is going to work where you have fundamental differences at a political level. So the idea of, I just want to say, the idea of how to go forward from this into, has been also taken up by various other reports. The Smith Commission, which looked into the post-referendum situation in Scotland in 2014, made recommendations for transforming this committee. And a Welsh committee, a committee of the Welsh Assembly, also made similar recommendations. It was called the Silk Commission. And it argued that there should be a more formal bilateral engagement between governments at this sort of level. So this question of fitness for purpose has come up really in relation to the Joint Ministerial Committee. As far as the concordats themselves are concerned, they've been heavily criticised for being dominated by Westminster and by the fact that the writing of the concordats initially, the culture of Westminster kind of prevailed in the way that they were initially drawn up, and that there wasn't enough input put into them in order to make them user-friendly as far as the devolved administrations are concerned. And the final general critique was that the lack of transparency as far as all of these mechanisms are concerned. Now, we've heard that this is a double-sided coin, that transparency doesn't solve all problems, but there are some things which should be in the public domain and some things that shouldn't. Anyway, I will bring my remarks to a close. I've just got a few things to say at the end. We're living through a period of great uncertainty. The deep-rooted political disharmony is exerting unforeseen pressures. Falling back on sovereignty, which the courts have done, not just in the AXA case, but in this recent case, by saying, you know, you've got to rely on the old principle of sovereignty, seems a bit misplaced at the moment, as the fundamental institution of Parliament itself has recently failed to reach consensus and deliver an outcome to the many questions posed by Brexit. And the whole basis of the Constitution, based on Parliament, is called into question as a result. It's perhaps surprising that there has not been more litigation, but maybe legal challenges will become more prevalent as Brexit kicks in, and also with the Scotland Act of 2016, with the change to the financial legislation. It's difficult to see how the fine-tuning of the institutional framework of devolution, by having just a changed structure, will solve the problems. I don't think it will. We've got to go through, I think, a very difficult time in reconciling what's going to happen next, and this may well be a second referendum as far as Scotland is concerned, and I haven't even mentioned Ireland, not because I don't want to or don't think it's important. I think it's extremely important, but I'm hoping that I'll get another invitation to Trento, and that maybe when I come next time, I can say something about Ireland. Okay.
Very good. Thank you very much. So I'm delighted because I know you are coming back to Trento. Let me just point out that, as usual, the UK follows its own or her own track. But still, despite of this, there's plenty of areas that deserve to be compared with what we heard from other countries this afternoon, although the setting is different, the history is different, but of course the needs are there, and the needs are quite similar, even though we don't have to go through the difficulties of Brexit. Let me just tell you that because of my own age, when you said the House of Lords, I felt perfectly comfortable. I knew exactly what you were talking about. So that's good enough. All right, I think that we are perfectly on time. We can have another short break, which I think everybody will enjoy, and then come back for another round of discussions. Now, I forgot to mention that Professor Nico Stadler had to leave and had to go back to South Africa ahead of time. So he could not join us today. And of course, he won't be able to draw any conclusion. So I think that without even any desire to replace him, at the end of the discussion, we can just draw our own conclusions and that will be it. So we may end up a little earlier than the 18:30, which is planned in the program. So let's have our break now, and we come back in about 15 minutes. Generous 15 minutes.
Okay.
So here we are again, although somebody is missing, but I'm sure everybody will be here soon. Let me just confirm that for dinner tonight, some taxis, in fact 2 taxis, will wait for you out of the hotel. You can take the taxis and they will know where to take you. And dinner will start after all of us will have arrived there. At the same time, some of us cannot remain for dinner, and this is in particular Anna Gamper and Valerio Nida. So I would like to suggest that if there is any question or comment on the presentation by Anna Gamper or by Valerio Nida this morning, this is the time to raise the issues, because then they will have left. So we give a priority to them also when it comes to the answer. So any question or comment? Is everything clear enough? Yes. Oh, yes, please. Could you kindly give him the microphone? Thank you.
You need to press the button.
It's not a question, not even a comment. It's more a kind of cliche. But as an echo to what we have the opportunity to discuss last night, I think in constitutional matters or federalist stuff, there is no such a thing like a legal transplant, because for lots of reasons, in Belgium, we are very inspired by the German system. For example, not only in the federalism stuff, but for example, the proportional electoral system, or the mechanism of responsibility, of political responsibility between government and parliament, but also about, of course, the loyalty, the federal loyalty, which was directly imported from German constitutional order, or of course about the composition and the way of functioning of our second chamber. But in practice, when I hear Professor Sommermann, the things we import from Germany don't really function as they function in German, and that's why your exposé was very useful, to go back to the roots of our system, because our roots makes completely the transplant as an illusion, in fact. That's all. I told you it was a cliche.
Any more? Then I would like to ask a question to Anna in particular. Now, one of the salient features of Austrian federalism is that it is one of the European old federalism. Whether weak or strong, certainly it is an old and consolidated and well-rooted federalism. Of course, also in the case of Austria, as in the case of Germany, there is a tradition which goes even beyond the text of the Constitution, in particular to the Austro-Hungarian Empire and the Kronländer and the history of that particular country. So I would like to ask you, how much is Austrian federalism thoroughly a cooperative federalism? And is there any area in which Austrian federalism is dual? And I ask you this question because certainly from the point of view of the awareness of the lender, you can, and certainly it is the case of Tyrol, you realize that there is a sort of land pride, which is also rooted in history. So isn't this somehow contradictory that there is such an awareness of isolation of one's own history, and at the same time one is entirely within a network of cooperative federalism? So is there any area of dual federalism that makes up the identity of each land?
Land identity, or you mean an identity of the lender as a collectivity?
Let's put it in another way, more, let's say, as a political claim. Is cooperative federalism the stated purpose of policies by the lender, or is it a sort of second best? In other words, the first priority would be more of a dual federalism. But because of the network, then all the lenders, even those with more historical awareness of their own identity, are willing to be part of a cooperative federalism. I said this because in Italy, some regions would certainly endorse a more dual regionalism than a cooperative one.
I'm not sure whether this works. It has lost us. I'm not sure. It does, yeah. Well, it's a complex question. First of all, because you alluded to the past of Austrian federalism. We conceived the beginning of federalism perhaps 1918, or at least according to the Viennese School of Legal Positivism, even 1920, because we maintain that the monarchy was a decentralized unitary state, but not a real federal system. And there has been some discussion between the Innsbruck and the Viennese schools of law whether the real origin of federalism lies in the year 1918, after the end of the First World War, the foundation of the Republic, because at this moment also the former crown lender of the monarchy said they would also agree to be part of the new republic, while the Viennese say it's just a proclamation which took place in Vienna, and those political declarations in the Länder themselves were not important. They rather say the enactment of the Federal Constitutional Act of 1920, this is the beginning of federalism. So there's a bit of a discussion. But of course you're right regarding the culture, the historic identity, all these things of course go back for a long time. So especially the Tyrol has had Salzburg, well yes, it's a bit a different history because Salzburg joined the empire of that time only at the beginning of the 19th century. So that's interesting to see. And then there are others, Styria for example, Carinthia, and they joined Austria, whatever it was at that time, because the name changed, you know, Empire, Austrian Empire, Austro-Hungarian Empire, and before the Austrian Empire it was rather an archduchy, and empire was the whole Roman, you know, Holy Roman Empire, not exactly the Habsburg Empire. So every land has a history of its own, and the Tyrolean one is perhaps a bit special. It joined the archduchy, so to say, in the Middle Ages, so at a quite early date already. And I wouldn't say, perhaps that there hasn't been a conflict between those Länder. In the sense, if we look at the United Kingdom, for example, we can say that I think Wales was conquered by England or Ireland, Northern Ireland, Scotland not, obviously. So we don't have this history in Austria, a mentality that the Länder, you know, had a historical moment where one land fought the other or was conquered by the other. It was rather by marriage and such things, soft instruments, so to say, that the whole system was joined. And I think this is something which we even now feel to some degree. This may be an answer also to your question. Perhaps Vienna is a bit particular. If there is any kind of hostility or rivalry or whatever, it is perhaps against the capital Vienna, because it's a land, it's a municipality, it's the capital, it's in the very east, it's much larger than the rest of Austria. Perhaps Western Austrians think this has many cultural links as well, the dialect and so on, that the Viennese do what they want and they feel, you know, capital people, a bit perhaps like Rome or others.
But there's no challenge to
that's right. So this may be a part. And then also the Western Austrian Länder have a stronger federalistic mentality. Vorarlberg especially, also the Tyrol, also a bit Salzburg, a stronger federalistic mentality perhaps than the other eastern or southern Länder. So this may be a difference. But on the whole, I think it's not, as you said, second best option or so. I think on the whole, the Länder themselves really are, you know, cooperative, or they have a cooperative tendency. There is no real hostility between them when it comes to a cultural or mental or whatever background. Yeah.
Oh, sorry. Microphone.
No, you can use that.
Yes. I was just, the follow-up is simply about when Karl Peter was talking about the role of Parliament and the Bundesrat, which obviously is very familiar in Germany as in terms of the legislation. Would you say that there are important differences to be made in the role of Parliament in relation to the making of laws in compared to Germany?
Very much indeed.
Yes. Could you just amplify that? Because I'm sure you said it, but I didn't quite pick up. I'd just be interested in how you would put that distinction.
Just to make sure, Maria, you have a question for Anna?
Sorry if I interrupt.
No, perhaps it is easy because she has time constraints.
No, it's fine. I have still 25 minutes or so.
Okay.
Well, it's strange indeed that the name Bundesrat is the same in Germany and
Yes.
Federal Council and in Austria, but there are big differences. First of all, with regard to the organization, because as you mentioned, the members of the Länder governments form the Federal Council in Germany, and with us, the parliaments of the Länder elect the members of the Federal Council. It's no direct election, but neither it is...
So it would have been like the Italian system would have been if the reforms had been accepted.
Well, in Italy, you have a direct election of the...
After the Renzi reform.
The Renzi reforms.
Oh, so yes, after
Yes.
it, yes. Mm-hmm.
Still the Austrian system is better. That's all for Renzi system.
I'm not sure of that.
I didn't mean to...
Both systems have one common feature, namely the, as I call it, asymmetric or geometric representation, weighted representation in Germany, and with us it's also some kind of asymmetric representation. When it comes to functions, there's a big difference, because the Federal Council in Germany, even though it is no perfectly bicameral chamber, and it also lost some competences after the first reform of federalism of 2006. But nevertheless, it still has some major powers, and there is the mediation committee, and this also means some sort of symmetry between both chambers. This is not at all the case in Austria, because normally, the Federal Council may take part in the federal lawmaking process. There are a few exceptions where it must not take part at all, but mostly yes. But then it exercises a suspensive veto, which can be overruled by a second decision by the first chamber. And there are only very few cases where it exercises an absolute veto. And even where this is the case, it normally doesn't make use of it at all. There was just one example 2 months ago. This was the first time ever that the Federal Council really exercised its absolute veto powers, but again, not for federalistic reasons, but because of party politics, because the Social Democrats wanted to oppose a project launched by the federal government. So both politically and legally, it's an extremely weak chamber. And even though there are some theoretical functions which could be interesting, nobody thinks about them. For example, I've been saying for quite a long time that the Federal Second Chamber could indeed exercise a sort of preventive scrutiny of bills, like, chambre de réflexion or whatever. Of course, it could be overridden afterwards, but it would be something to say, well, this is unconstitutional, we will not let the bill pass, so back to the National Council, the first chamber. But it doesn't do so at all, not at all. So that's a pity indeed. And so we've had a discussion for quite a long time whether to abolish the Federal Council or to replace it by another more effective body, but nothing has happened as yet.
Thank you. Thank you very much.
Are members of the Federal Council also at the same time be members of the land parliament?
They may be,
They
but
may
they
be.
need not be.
Just to add to the confusion, we also have a Federal Council, but it's the executive body. It has the same name, Bundesrat. Before Anna has to leave, I have a question about your view on courts giving expert opinions. I have a lot of sympathy for the idea, but I also see some risks, because as a court, you don't have a case in front of you. It's more of a theoretical question. Now, you give your view, it's not binding. Parliament decides otherwise. Well, what does that do to the reputation of the court? And if the bill is then accepted, you can do abstract review, where I think as a court you're then bound by your expert opinion, because it's still the same law. But then after the abstract review comes the concrete review. So you could have 3 times the same bill in front of the Constitutional Court. And I wonder whether this is a good system, whether the same body doing solution of real conflicts as an ultima ratio should be the same that does preventive constitutionality check. I rather like the idea of using a second chamber for that. I also have found it quite interesting that the Institute of Federalism, of which I'm part, has been given a mandate. I can't talk about it because it's not a mandate, it's the mandate of my colleagues, a formal mandate of the government to do constitutionality review for all the bills. And the system is to do a traffic light system. It's either red, green, or yellow. And I find that quite interesting as an idea, to have a totally apolitical body that gives, on an official mandate, a first appreciation. It's good, it's bad, or take another look. So I would like to know whether you have any sympathy for that solution. I have also been intrigued by what you said about the level of scrutiny. When there is a political agreement, the signature of both sides creates a legal presumption of constitutionality. I very much like the idea, and I think it could be interesting for a comparison. What is the level of scrutiny? How does it affect the way we solve conflicts? Because if you know that, we've heard it from Peter as well, if the threshold is very high for the Supreme Court to even look at the matter, that gives you a very strong incentive to negotiate well and to find an agreement that is acceptable to both. So I wonder how much we could get out of a comparison of the level of scrutiny, because I think as an ultima ratio there should be possibility to go to court, because when you negotiate or you make a bargain, you have inequality of bargaining powers. So maybe that is helpful for the weaker partners to know that if it really goes wrong, there is an independent body to whom I can turn. But if it's more or less making everyone a bit unhappy, then that's it. That is the political agreement. So that invisible partner out of the court impacting or somehow probably framing negotiations. I find that a very interesting idea. I think in our situation the referendum plays that role. You negotiate, and if it's more or less acceptable, that's it. And if it makes some people really angry, then you use your veto right as a population. So I wonder whether you can compare maybe the two mechanisms. Thanks. I also have a question for Peter, but I know you're staying. I can even ask them during dinner.
Thank you for your questions. They are extremely interesting. First of all, to the question of pre-legislative scrutiny. I think, first of all, we have to differentiate between different kinds of scrutiny, because during the morning and also the afternoon session, I sometimes thought terms were perhaps a bit confused. The one thing is preventive or ex ante review and ex post or post-legislative review. And the other thing is concrete or abstract review. And I think we have to be quite clear about the differences of these different kinds of reviews. Now, with regard to the Austrian Constitutional Court, it is interesting that the Constitution, as I said before, vests the Constitutional Court with this pre-legislative scrutiny only with regard to a very narrow question of constitutionality, not whether a bill is totally in line with the federal constitution, but only with regard to the allocation of powers. If the bill, for example, would violate, if it became a law, would violate human rights, the court mustn't say anything about it. It's just a powers question. Now, I said before, it's like an expert statement. It is difficult to say. So what I meant is that the court delivers an opinion on a concrete bill, combined with an interpretation of the concerned subject matters. And usually part of this pre-legislative judgment is called Rechtssatz. It would translated, it would mean legal statement or whatever. And this very part, at the core of the decision, this is considered to be binding by the Constitutional Court itself. The court says this core statement is or has even the rank of a constitutional law. When it comes to post-legislative scrutiny, the court will itself feel to be bound by that former pre-legislative statement and will use this statement where the court interpreted a subject matter as if the federal constitutional lawmaker itself had defined the concerned competence. But this pre-legislative statement does not at all hinder or put an end to the legislative process. And this is what I meant when speaking of an expert statement, because in the legislative process, the decision has no force to finish the legislative process, to put a final blockade towards it. It's just a statement, and then the parliaments may themselves decide whether they continue or not. But afterwards, if they really venture on to continue with the legislative process, of course it's a risk. And they enact the law, and somebody challenges it afterwards before the court. Then the court will remember, this is what I meant before. So it's not non-binding, but the question is whether we arrive at a stage where the valid law is challenged before the Constitutional Court. Everything depends on that. And if you look at the constitutions that provide for such a pre-legislative scrutiny, the French and others inspired by the French and Constitution and so on, quite a number of constitutions worldwide, you'll find always different models. Some models where the court says no, and then it's no, and the whole legislative process is finished. Or it's no, and they may continue. So there are two models. And I think finally it is a decision for the constitutional lawmaker. I think the principles that come into play here are democracy and the separation of powers. And in the Austrian case, the reason was that the constitutional lawmaker said, this is primarily a legislative process. It's a matter primarily for a legislature, a parliament, and not for a court to put an obstacle within the course of that legislative process. The court is not a positive lawmaker. The court is not part of the legislative process. Afterwards, yes. And that is the reason why there is such a small, tiny little competence of pre-legislative review, because the separation of powers would a bit be violated from the Austrian perspective if the court really had a more decisive say in the legislative process. Also because the judges are not directly elected by the people. So this is one reason. Now, you mentioned a mandate for an institute. That's very interesting indeed. Of course, again, the same issues arise. It will perhaps, defer the legislative process to some degree if an opinion has to be waited for by that institute, and then I assume it's not binding, but just an expert opinion, or yeah. Well, it depends. One could say, well, it's not binding, just let's wait for it. It's useful to have it. I think that's a decision. It's reasonable. And I think Austria, it's not so far away from what you mentioned, because normally in Austria, we have, when a draft law is being made, usually by a ministry at federal level, we have a very informal practice, but it's not in the positive text of the Constitution, it's just informal, that most drafts are submitted to a number of, let's say, institutions that may say something on this draft, and then it goes back to the ministry, and then the ministry will consider or not those statements made by some institutions, and then it will continue, and then the federal government will have another look, and then, only then, it will be a decision to table it. So it's before the National Council, the first chamber, and then the legislative process will start. So it's a very informal practice, even earlier to the real beginning of a lawmaking process. And it's a number of institutions that may deliver such an informal statement. My department, for example, we sometimes also get, a letter from a ministry. Do you want to say something on that? We could, I myself personally, I think I made 2 comments on 2 bills or drafts. In this case, one, so it's possible, but not, of course, necessary. Well, now, and then the second question with regard to the legal presumption by the Constitutional Court. I must say that what I mentioned is the absolute exception. As I said before, the Constitutional Court normally has this very positivistic perspective. So it's just, and this is so fascinating from my point of view, it's just regarding this Financial Equalization Act, that the court says, well, I assume that if all partners agreed on it, then what is the complaint? It would be absolutely irrational for them to sign it and then say afterwards something is unconstitutional. But I think the main reason behind this attitude, because it's only to be found in this case, that the court considers this political agreement to be relevant, is in fact, I think it's a very pragmatic approach, that the Constitutional Court's judges do not really feel themselves perhaps this is a strong word, qualified, really to determine whether, let's say, the complaint of a municipality, I get, don't know, 2 million euros from financial equalization, but it would be better to get 2.5 million. That's the complaint. How should a constitutional judge assess this? I think that's the main reason behind this attitude, because the judges, as lawyers, do not feel themselves inclined or suited to judge on the question whether the Financial Equalization Act should put 1 million euros to that level or to that, because it's not really too many numbers. Yeah, perhaps. So the court says only in excessive cases. The court said, that's interesting, the court said in excessive cases, then even despite the political agreement, the court would like to scrutinize it, but not in non-excessive cases. And that's exactly, I think...
we use the term merits review. I don't know whether you use the same term or something equivalent. Merits review.
Yeah.
That the courts say they don't want to be involved in merits review, that they want to be dealing with a hard-edged legal question, not deciding on the budgetary excesses. Yeah.
Dogmatically speaking, it's about the margin of appreciation. No?
Yes.
Is what the legislator has, or in this case, the community, no, of those involved.
Yeah.
So it's not about really if a norm really orders a certain behavior, but that interpretation of the norm is giving margin of appreciation.
Yes.
But it's not explicitly said, margin of appreciation.
No, it doesn't say so, but you know, there is a constitutional principle that governs the whole issue of financial equalization. It's a very vague principle. It just says when enacting the Financial Equalization Act, the federal lawmaker needs to consider the capacity of each level and also the administrative burdens of all levels, and needs to adapt financial equalization to the needs arising from that. So that's the rule. How to assess it? How to assess it in numbers? It's really difficult. The court would, I think, be, the court could, in excessive cases, say, let's say a very exaggerated example, the Financial Equalization Act would say the municipalities don't get any financial revenues at all. So the court would say, no, that's irrational, of course. But if it's just a question of 2 millions or 2.3 millions, how is it really a legal question? I think the court wants to avoid, deciding on such matters. And so it says, well, you have agreed on it, it will be rational, it will be fine. And that's it, I think.
I'll just say it is non-justiciable. It will be, I suppose, the same result. Rather than saying it is, there is an assumption of constitutionality, you could say it is non-justiciable. And so I don't have legal or normative benchmarking in order to make my evaluation. Yeah. Now I hate to, but I don't want you to I hate to see you leave.
Oh, yes,
but I don't want you to miss the train. Any other question? To Anna, no? So then we continue with the other papers. So thank you so much for your great contribution that you gave. I hope to see you soon.
Bye-bye, Anna. Bye-bye, Anna. It's been a pleasure to see you again.
Goodbye to all of you.
And of course, you know the way. Yes. Thank you, Anna. Bye-bye. All right. Of course. Now we have 2 more papers to be commented.
No question. Or...
No, it's
well. I wanted apologizing for my very poor English. Thank all of you for your very, very, very interesting interventions, and thank Roberto Toniatti for this initiative. And share with you, if possible, a small reflection on what, not a technical reflection, but a more general one. What can we in Europe learn from the different experience of federalism or federal cooperation and also controversies, ways to solve controversies? I think that we can learn one thing. The future of Europe is not the Europe of nations. We are accustomed from the history to consider that a nation is the basis for a political unity, the Europe of nations. But the history tells us that, one, the nationalism produced wars among the different nations in Europe. This is the history of Europe. When the French minister Schuman in 1950 wrote the declaration, the famous declaration, he said that we have to make something that makes a new war in this context not only unthinkable, but materially impossible. It is something different. It is something ideal, but the way to avoid new wars is not only the reasonable decision and so, but the war must be materially impossible. That is, our life must be organized in a way that it is impossible to in a war, because the coal and the steel and coal must stay under a common, they have not to depend from Germany or from France, but from a common authority, the first one. The second is really the nations without an idea of cooperation or remaining risk was splitting, because we say in Spain there are the Catalan question. In Great Britain we heard that it is possible that the Scottish leave the United Kingdom. It would be a revolution, something unthinkable. Maybe Belgium, the difference in Belgium. On the other hand, there are multinational states which remain and are solid, because Switzerland is an example. It's a multinational, three languages. I think also difference, cultural difference, and they remain. Now also, I had the Germanophone people in Belgium who are very they love their autonomy. They want their complete autonomy, but they are strictly tied to the Belgium, to the King of Belgium. That is, the solution is not nations, Europe of nations. The solution is Europe of the differences. There are differences. We have to search what is common among different subjects, which remain different, not for what divides. Many things divide us, also South or Northern Italian. They are a nation, but the problem is respect of differences and searching what is common, in spite of difference, what is common. And there is something that is common. This is the question. I think yes, but I hope yes.
Thank you. Eva Maria, you have a question for Peter, I think. Okay. Okay.
Thank you very much. Carl Peter, I've been very happy to listen to your presentation because you have not been complaining too much about that joint decision-making trap, because so many of your colleagues keep describing the difficulty that lawmaking is rendered almost impossible by the existence of the Bundesrat, and almost suggest that the second chamber should be not disappear but being weaker. Now, you didn't portray the system in such a way, and I would like to know whether you think that the fact that the Bundesrat is so strong, is that the main reason why the hierarchical options are not being used? Because it's a preventive control. If the Bundesländer don't like the legislation, they just don't let it pass. And then you don't need to go to court because you have a very effective preventive device. And it's not a trap, it's a mechanism of conflict resolution that kicks in at a very early stage of the lawmaking process. Is that too optimistic as a view, or would you agree to that?
Yeah, thank you very much. Joint decision-making trap. In the 70s, when this theory was developed by Fritz Scharpf in the Max Planck Institute in Cologne, there was afterwards the conviction, this is really bad, this interwoven decision-making procedures. But you can nearly see like a conjuncture. No? Then still the reform of 2006 was inspired by this model, as you know. But afterwards, the opinion changed in Germany. Even Arthur Benz and others, Arthur Benz, one of his pupils, no? to develop these ideas, they are more critical now to this disentanglement, Entflechtung. Because they say there are certain rational elements in it. First of all, the fact that there are different actors in the decision-making process, this can contribute to make it more rational, because there's, let's say, an innate control in it. And on the other hand, it is seen that it is good to have a common perspective of both levels, federation and Länder. So I think the main support for a critical approach of the theory was when we had this blockade in the Bundesrat a long time, which did not happen during the last years. Partly now, because we have now governments of the Länder which are led by Green Party even, who have different positions. That means negotiations have become more difficult, but the outcome normally during the last years has been quite good. It means this also favors perhaps a less critical view on this. But I agree completely with you. I would see the advantages are really bigger. And we saw the law of 2006, which should disentangle the decision making levels, or did not lead to this positive result. We have now even more with the last constitutional reform of 2019. It's also a step again to nearer cooperation. No? If you see these federal influence on Länder level, which would be against this theory. Let me also, your question was, your last question, if the Bundesrat, if this avoids, yeah, is this one of the reasons? I would say yes, because finally the prime ministers of the Länder, they have the final say. Normally the ministers are there, but the prime ministers of the Länder, who then also normally sitting in the directing councils of their parties, they are influencing, of course, the acceptance of such laws. I think these are informal procedures more, but I think for sure this is one of the reasons. I only want also to add one point. We do not have only the procedure disputes between federation and Länder, but also the norm control procedures in which we have certain cases where the federalist aspect had been scrutinized. No? As I told you before, there must be an empirical work still to find out in how many cases this was really an important aspect for the decision of the court. So it is only half the truth if I say there have only been 2 procedures in 10 years. We would also have to look at this other aspect, but it's not so considerable, no comparison with the Italian case. I also want to make a short comment to your idea, what can we learn from the different experiences? We saw today that also Julien Pierret told it, that the same institutions may have a different outcome according to the context. No? The question of legal transplants, I think there's a very interesting question also for us as scientists. How can we perhaps predict or preview if a transplant may be successful or not? I think there's a big question. We know certain very easy things, that it depends on the context, on political culture and so on, but that's not enough to predict really something. And I think this is still a task to be done. What we can perhaps learn from these systems is that there are 2 elements in federalism, but also in decentralized governments, which are really necessary to integrate a state. This is first the principle of solidarity. If you look at the beginnings of the European community, you quoted the Schuman Declaration of 1950, where Schuman said, with the words of Jean Monnet, that we need a solidarité de fait. Yeah, this means behind this you have the knowledge or the insight that you first really need to interrelate the different partners, and then they will develop first a solidarity guided perhaps by economic interests, but finally also by a spirit perhaps of solidarity. This is the hope that this one day transforms, and everybody knows if I contribute, I have something back. We have no problems with certain states who think the principle of solidarity, it does not work very well. So this shows that it's really a danger once people do not have trust in this solidarity principle. And the second point, but intimately linked to it, is the loyalty. Once you decide to go in such a common political community, be it a state, be it an integration organization, integrative organization, you must know that it can only work if you are loyal. And of course, we have these efforts by the legislator, by treaties, to put certain hard obligations in it, but in the final resort, it depends on the common spirit which is behind it. So these 2 things, if they are well developed in the federal systems also, I think this must be the key. You must look if the mechanisms that you have in your country contribute to these 2 principles. And then you can look at the technical points, what is possible as procedure, as institution, and then you have to find out, perhaps by support of scholars who are specializing in this field, what are the preconditions really that a certain mechanism may function in this context. Yeah, but the legal transplant, this is really also one of my great questions. We are, my main field is comparison, no? And we often work about this, how to handle these. Already when you say legal transplant, yeah, you include already that it might be rejected, no? By the organ where you transplant it. So you have in this term, in this metaphor, you have already all the problem.
Also the fact that you must artificially build a root.
So
what is rejected is the root.
Is the root,
because
yeah.
it is artificial.
Yeah. But there are many examples where it functions very well, but the transplant has a different character, but it functions well. No? This also you can see in certain ombudsman, for example, this is a good example, quite easy to see. But this learning process we have in Europe and what we are doing here, it's more a process to learn from each other what works and to understand how can be the outcome under certain preconditions. I think I'm a bit skeptical, no? If this with the transplant, I think normally it's better in a system to have a kind of how do you say, organic development than just to say, no, we stop here, we make something completely different. I think this you need at the same time to change the context. No? I think all of us, we have to do with certain countries where we give advice. We see that these transplants often do not work. We have to work on the context.
In private law, where it comes from, some laws are copied across, they're literally copied across systems. But I agree with you very strongly that when you're talking about public law, with all the complexities that they involve, and all of these different levels of agreements, ethnicities, constitutional norms, and all of these other things, when you mix all that into the bag, it doesn't really work. As it, if you're just talking about contract law, contract is a contract, and if you're going to have a commonality between contract law, you can see that, okay, the same things you require, but it's not the same with public law.
That's why many scholars have said the less serves comparison or comparative law in the field of state organization, because it's so historically preformed. The counterexample are fundamental rights. There, perhaps also by the Convention of the European Convention of Human Rights and other instruments, we are more or less discussing on the same level. But as far as state organization is concerned, administration, it's much more difficult. I would never say we cannot learn from each other, but it's much more complicated.
I would say in the area that we have been exploring today, I don't think we experience legal transplants, but rather circulation of models, which is a different thing. Circulation of models is not directed from above, whereas a legal transplant assumes that there is a normative will to transplant one particular institute. Yeah. Okay, now we have, are you finished?
Yes.
Yeah. Andrew and Eva Maria for Peter, 2 questions. Thank you very much for your help.
Thank you. Just, if I may, a comment and then a question to Professor Leyland on his excellent presentation. Actually, what I wanted to say, I think, follows directly from the discussion just now about legal transplantation. If I might just explain, my own current research is on decentralization in Southeast Asia, and I was hoping to take away some comparative insight, if not actual theory, from today. And I have not been disappointed in that regard, because I've learned a great deal from several really excellent presentations. In Southeast Asia, the legal structures or concepts, if you like, that supply decentralization are in almost all instances directly copied from European precedent. So there's a considerable aspect of legal transplantation, and certainly there is a problem in terms of how these systems might work when transplanted societies that are very differently constructed in terms of ethnicity and so on. But what I really wanted to say about this, I mean, having lived extensively in 2 federal systems, Canada and Malaysia, and having lived extensively in one devolved jurisdiction, Her Majesty's disunited Kingdom of Great Britain and Northern Ireland, coming from there is a fact that I feel increasingly I should apologize for. I've become very mistrustful of these legal structures, and therefore I'm very interested in the sort of alternative ways, or maybe the legal aspect we should call now the alternative rather than the political aspect, in which these systems managed to survive and work at some sort of level. So coming from that, with that thought, to the whole situation with the devolved jurisdictions in the UK and Brexit, I just wanted to put out a proposition and see if Professor Leyland agrees with what I say about this. I mean, everything you presented was very interesting and very informative, and I agree with everything that you said. But surely there's the larger picture of all this is actually the failure of the politics of devolution. And that is strikingly indicated in the case of Brexit, because I think people may well recall that at the beginning of this process, the whole idea was that the UK government would consult with the governments of the devolved jurisdictions in conducting the Brexit negotiations. Nothing of the kind has actually occurred. And this is an extremely damaging political fact that may well lead to the complete breaking up of the United Kingdom, because basically what is being done through this process that Peter described is a constitutional outrage. And you can understand if people in Scotland, for example, who previously voted against independence might now want to vote in favour of it because of this outrage. So I just wanted to really suggest that if the politics of this had been handled rather better than it has been, then maybe all this tension and conflict that is having to be resolved through these various processes, the litigation, the operation or non-operation of the conventions and so on and so forth. I mean, all of that surely could have been avoided if some attempt was made to make the politics congruent with the devolutionary facts of the UK as we now find it.
I wanted to comment.
You want me to?
Yes.
I'd be very happy to comment on that. I think that the point that I sort of made in my paper is the idea that referring back to the referendum of 2014 and what happened after that referendum was the Smith Commission, which was set up specifically to take on board the enormous surge that the Scottish nationalists managed to receive in terms of the referendum, because when they went into the referendum campaign, they were standing at around 30, low 30s, and at the end they got 45%. So that's a huge increase. But during the course of the campaign, it was quite clear that there was a strong head of steam in favour of more devolution. And the Smith Commission and the subsequent legislation was very specifically geared to take on board those concerns. And as you were saying, exactly agree with you, to reflect the politics by giving powers which were in line with what was now the expectation. And then the Brexit situation took hold, and this is why the Miller case on this point of the Sewell Convention is so important, because this is where the consultation element was supposed to be a formal process and recognised as such. Now, nobody, I think, was arguing that the Sewell element meant that it was a veto, even the last type of veto, as you were describing, say, with Germany. But what they were saying is that there would be a formal mechanism in place that would have to be respected in all cases as part of a full process. And what has happened as part of the Brexit process is that the government initially set up this organ, the Joint Ministerial Council, and when it clearly wasn't going to work, they simply steamrolled through. And they ignored the apparatus that was in place, and therefore they made everything so much worse, because it was like a red rag to a bull type of thing. So it's exactly what, you know, so I'm echoing really what you say, in saying that it was a gross insensitivity to what had been put in place, both in statutory form, because, you know, contesting, I mean, the Supreme Court seems to have completely misjudged the position from the point of view of the devolved nations. They just took a narrow view. They didn't even answer. I mean, according to the articles and blogs that were written at the time of the judgment, they didn't take on board the argument. They just said, this is the situation in regard to conventions. As far as we're concerned, this is the Sewell Convention, and if they ignore it, fair enough. But that seems to me to be totally ignoring again what should have been the constitutional position. Because if Parliament has passed a law which says now the Sewell Convention is to be taken into account, you say, well, it's just a convention which is unenforceable. Well, why would you write such a law? I mean, it just seems bizarre. So I'm sorry, going over the same ground. So I do feel that we have played fast and loose with what principles we've had. And just to give you another one, which is much worse in a way, which is the fact that Mrs. May was defeated 3 times on the Brexit vote, and she did not resign. Now, of course, we have the Fixed Term Parliament Act, and this changes the procedure, because this would not have happened before the Fixed Term Parliament Act. I think there's consensus on this. But the point that I'm making is, it doesn't matter what the Fixed Term Parliament Act says. The essence of the convention is that a government must be able to govern, and to govern it must have a majority in the House of Commons. And, you know, I'm not necessarily personally, we're talking about, you were asking me about emotions and everything else. I'm not personally, I'm not a Conservative, first of all. I've never voted Conservative in my life. I'm not a supporter of Mrs. May or of anybody who's going to succeed her, but from a constitutional legal point of view, I feel that she should have stepped down and that somebody else should have had a go, because as far as I'm concerned, and as far as my reading of the Constitution is concerned, it's a constitutional outrage that we have a government which is not governing, because no other legislation is going through Parliament, incidentally, apart from the budget and, you know, to pay the civil service and so on. We're sort of in this state now of a frozen state because we can't deal with the Brexit problem. And it's you know, every day I don't want to look at the news. Personally, I just, you know, I would not when you know what I mean, because of this situation.
I experience the same, mind you.
Yes. So just to go back to what Andrew is saying, I very much agree, because if you don't have a codified constitution, the conventions of the constitution are absolutely fundamental. And if you ignore them and play fast and loose with them, the whole edifice begins to look completely unsound. And if we'd had another person taken over, at least they would have had a chance to try to form a consensus around their view of what should happen next. At the moment, we're frozen, and we're wasting time, and everybody else, you know, Rome burns.
And then, if I'm not mistaken, John Major replaced Mr. Thatcher without an early dissolution of Parliament.
But that wasn't
even with a fixed term.
Yeah, right. Now, the Mrs. Thatcher succession is a different case altogether, because there was a stalking horse candidate under the leadership procedure, which was triggered within the Conservative Party. And it wasn't to do with Parliament. It was to do with the fact that that has been a possibility under the rules, that a leader, I mean, Gordon Brown succeeded Tony Blair without an election because there was no candidate who stood against. So it's not unprecedented in our system for the Prime Minister to change without an election.
That's what I
but
meant.
the precedent that I think Andrew and myself would quote is 1979, when James Callaghan was Prime Minister with a very small majority, and there was a vote in 1979 which was lost by one in Parliament. He immediately went and asked the Queen for a dissolution. And that is a confirmation of a convention that was formed. I mean, I'm talking about over 150, 200 years, that has to be, the government had to enjoy a majority in Parliament. The Fixed Term Parliament Act, just to be precise, I'm sorry to go on and on about but just to explain, the Fixed Term Parliament Act says that there are two contingencies where an election can be held not with a 5-year break. One is if there is a formal vote of confidence, which there hasn't been. This is because the Conservatives don't want an election, incidentally. But that's how they've escaped it. Or if there's a 2/3 majority of a supermajority within the House of Commons in favour of an election, which is what happened in 2017. But those are the two situations that are envisaged under that piece of legislation. Okay.
May I ask if this?
Yes.
Does this rule apply to each bill or decision to be taken by Parliament once the government brings in a bill and does not have the majority? You would say this immediately, or is it dependent?
We're talking about government legislation. There may be private members' bills or private bills, but government legislation.
Yes, I mean government.
Government legislation. It's normal for the government either to withdraw if they know they're going to lose. They will withdraw the legislation. Normally, if they lose on a vote on the second reading or on the third reading of the legislation, this is when previously there would be the normal thing that would have happened before the Fixed Term Parliament Act is that there would be an automatic tabling of a confidence vote. And when we talk about this, I mean, it's not, we're talking about transplants and so on, but talking about, Andrew has written about the Westminster model and so on, and when we talk about the Westminster characteristics of Westminster model constitutions, this idea of having the confidence is one of those characteristics. I mean, it's something that you would say is something which Westminster, because of course the United States type constitution.
But in all parliamentary forms of government,
yes,
confidence is assumed.
Is assumed as a necessary element.
Yes.
Okay.
Eventually, Eva Maria, please.
Sorry.
I will,
Your microphone
Andrew
is
and Peter have raised the issues I wanted to raise, right. So I was just happily listening to what you were saying. But since I have the mic, I first would like to come back to legal transplants, because they have been questioned so severely, and I'm so fond of them. I think if we look at the constitutions of the world, they all look very much the same. And that is not true for criminal law, environmental law, it's not true for any other field. They all have human rights catalogues, they have a separation of power, norms on revision, and so it may be more a circulation of models and sources of inspiration, but constitutional laws have been so closely working together. And it's not a new phenomenon. I mean, our bicameral system is a direct import from the United States. Human dignity is an import from Germany. So I don't think it's a problem. It's just the fact that once you transplant a norm, it develops its own life. You can't copy and expect to have the same outcome. It's, as you've mentioned, Article 155. Of course, it works out very differently in Spain, because there is no Bundesrat vetoing decisions on the national level.
There are no Catalans in Germany.
Maybe there are, but there are Bavarians.
Okay. I take it.
So I think we should learn more about how transplants work, how they are contextualized, but I don't think we should oppose them as such. Talking about these transplants, whenever we look at power sharing mechanism, it's usually about self-rule and shared rule. So when you devolve a system, as it has been done in the UK, there is diversity of policies, there is self-rule created in Scotland. But there is so little about the shared rule. How do you produce common rules? Because so many matters are, and that's now Austrian terminology, are complex matters. They affect all tiers of government. So you need to have mechanisms to produce shared rules. And I wonder why this has not been possible in the UK so far. To find an effective mechanism of joint decision making. And I wonder whether that has to do with that concept of sovereignty being concentrated in Westminster? Or could it be its parliamentary sovereignty? Would it be thinkable that in UK we witnessed the development of a parliamentary sovereignty shared by the parliaments in Westminster, Edinburgh, and Wales? That Parliament is not one entity, but it's a variety of entities working together. So that's one of the conclusions I take home. What do we know about ruling and regulating complex matters? And the political agreement that Anna has been describing, it's an ad hoc agreement. If you have a complex issue, you first agree jointly on goals, programmatic norms, and then you work on it. Do you think that would have been an option for Brexit, or is it still an option? That you first decide on how you decide?
I don't know about that.
Yeah, may I just add a footnote? You mentioned protocols between parliaments.
Yeah.
And as a matter of fact, it is the only case of protocols between parliaments that we heard of today. Normally, such agreements are between the executive of the different layers.
No, the concordats are between executives, not between parliaments.
But you mentioned there are protocols also between parliaments.
Yes.
I meant
also take a note of that.
I said that this is to do with the Sewell Convention.
With the Sewell Convention.
Yes, absolutely, okay. With the Sewell Convention. But I have an answer for you. The answer, I don't know whether it's a satisfactory answer, but the way I see it, anyway, from the point of view of understanding, I see it by, if I give the example, that the UK is the opposite of Italy in this sense, that the effect of devolution initially, 20 years ago, was, and this is again to do with how it was seen as a political settlement, and as rather a clever political settlement, it changed the democratic foundations of the United Kingdom by introducing an intermediate level of government between central and local government, and it introduced lawmaking powers But what it did was to base all that on a generous financial settlement. And the generous financial settlement contained in the Barnett formula meant that the Scots particularly, but also Wales and Northern Ireland, were given a bigger cake to divide than was for the equivalent parts of England. And that meant that the Scotland started with a level of finance where they could divide their own cake. And so if they wanted to spend more on student grants, as they did, or more on health, they could do so. Now, the problem, when I said the opposite of Italy, the problem with regional government, I mean, I'm sure Roberto will put me right here if I explain this wrongly, but as I understand it, the situation that has caused so much friction in Italy is the question of how you prevent too much money from going to non-productive regions, or regions that are perceived as being non-productive, so that they're seen as kind of, this becomes a perpetual problem as far as Italy is concerned. Now, that never arose in our system because Scotland got more, not less, in terms of what it was given. So this issue about the basic idea was you've got your extra money under the Barnett formula, you go and spend it how you like in Scotland, Wales and Northern Ireland, according to your own executive and your own democratic system. Now the system is changing because now Scotland is raising income tax and VAT, a substantial amount of VAT locally. And when I said before that this may lead to greater litigation, I don't know how this is going to work out, but it may well set up, because if the base, what I had in mind when I said this, was that Scotland is very small in population terms. It only has 5.2 million people. The tax base is small, and if the effect of reducing the amount that's raised under the Barnett formula and increasing the amount of direct taxes, this may cause all kinds of frictions between the Scottish executive and Westminster, which we haven't yet experienced. And this may call for new forms of dispute resolution or whatever, or renegotiating concordats and all of the things that have been going on, and to more litigation. But I think the reason that this hasn't arisen, as I said, is simply because of the way that devolution was introduced. I don't know whether that seems a fair answer. I don't know whether... Andrew, does that sound, would you agree with that or not? I don't know.
I would agree with that. I didn't realise it was completely different from Italy.
Yeah.
I would agree also.
Yes. Okay.
Maribel, Julio, any question? No? Well, I think it is very interesting that we end up with the United Kingdom and its own unique experience. Let me just say very few words that might not give some concluding remarks, but just some wrapping up what has been said today. I think that we had a great exercise of collective learning from each other. Once again, we learned that government is not only a legal problem, and federal government also is not only a legal problem. It is quite more. And we found out to what large extent the culture of federalism is important, and from this point of view, as it has been said, the the older or younger age of the federalism or regionalism or devolution experience in a given polity is very important. The culture of federalism is, let's say, the precondition for understanding how to make federalism work in the best way. And this, of course, has to do with conflicts. As always, constitutionalism does not aim at eliminating conflicts, but at managing conflicts. Conflicts are going to be there, and it seems to me that one first step within the federal systems which have been taken into consideration today is to learn how to go beyond a dual system of federalism, to the extent that perhaps, and I emphasize perhaps, we might even establish a connection between dual federalism and judicial resolution of conflicts, and on the other hand, cooperative federalism and non-judicial resolution of conflicts. From this point of view, the relatively young Italian regionalism would indirectly suffer of a dual approach. And the dual approach still has to do, I would say, with the claim of the center to be I don't want to say an authoritarian center, but certainly a center which is beyond the network of consultation that we have been talking about today. Just to make to give one more piece of information, in the case law of the Constitutional Court of Italy, the principle of federal loyalty does not apply to the legislative function, not only to the administrative function or to the policy-making function, not when it comes to legislation, which of course is an incredible shortcoming of the full application of the principle of Bundestreue. So if there is this connection, dual federalism and cooperative federalism, what has to be found is the proper role for courts. And here we had a number of experiences. The reason why I prefer to look at the different compared experiences as circulation of models rather than transplant, because I see a sort of parallel, spontaneous track towards adopting certain criteria of behavior, leading ultimately to consensus federalism and consensus democracy, has been said, concerning Switzerland, which from this point of view, I would say, is still a model. We have seen in Switzerland, in Austria, in Germany, certainly more than in Spain and in Italy, that there is a plurality of networks of consultation and coordination. And I wonder if, taking together all these networks, we might speak of a sort of functional equivalent of the German Bundesrat. Of course, the German Bundesrat is still the prince of the second chamber, so to speak, only the German Bundesrat. Other systems are trying, through different ways and instances, to duplicate the function, the function of the Bundesrat, although only in an equivalent pattern. The Bundesrat is crucial, but even without the Bundesrat, according to the German model, there are other means, procedures, mechanisms, formal and informal, and once again in Switzerland, this is certainly very true. As it is very important also to take into consideration horizontal coordination and the possibility of writing and signing treaties among the different actors of government. I think that Spain is to be praised because they have learned a lesson from more mature federalism And Spain has tried to introduce, through an amendment to the organic law on the Constitutional Tribunal, again, something which might sound like a functional equivalent of mechanisms that are directed and headed towards solving the conflict. Again, we have the example of Belgium, which is extremely interesting because it shows how as I said earlier, in fact, as Julien has said, the more acute the political problem is, the less likely it is that it will be decided by a court decisions. And all this shows to what extent policy making, party politics are still an essential component of government, and of course we knew that. I would still, just the final remark, I would draw a distinction between systems in which avoiding a court decision is a collateral effect, and this is Germany, and or even Austria, in countries in which there is either as part of the legal culture or as part of the codified constitution a rule to the extent that judicial solution of conflict is to be avoided or is to be considered as the extreme ratio. One more remark, I'm sorry, but I have to make it because it has been mentioned a number of times. We have normally taken for granted that federal tension or federal conflict have to do only with the allocation of powers. A number of times it has been mentioned that issues of federalism relate also to fundamental rights and fundamental freedoms. And this is true in particular for those federal systems in which the Länder or the cantons have their own constitution, and their own constitution dealing also with fundamental rights, as is the case of Germany, as is the case of Switzerland. Now here I think that we do not have, I would say, largely spoken about this particular situation. I take for granted then it has not been an issue in the different jurisdictions which have been explored today, but we still, I would say, still have to keep in mind that when fundamental rights are concerned, of course, the role of courts is essential. And I would never like to see an assumption of constitutionality when there is an intergovernmental agreement which is undertaken unanimously. So I think it has been a very interesting seminar, very high-level discussion. I would like to thank you very much again for taking the trouble of coming so far to Trento from your own home countries and universities. And I hope there will be another possibility of meeting here in Trento. And one of the potential topics is advisory opinions by courts. And this would include also, I suppose, the European Court of Human Rights after the 16th protocol, would include also Canada and Ireland, and South Africa, all right, that I was not aware. In Canada and in Ireland, they have two different attitudes in terms of the final judgment by the Supreme Court on constitutionality. And that, of course, is always very important. So keep in mind that judicial advisory opinions may be a topic for another meeting next year.
We have declaratory judgments as well.
That would be included. All right, thank you very much, and we can close the proceedings of our European colloquium now.